row seat to democracy.
The Senate Judiciary Committee held a hearing on the right to carry a concealed weapon in public following a Supreme Court decision over the summer that struck down a New York state law requiring proper cause for a concealed carry permit. Gun safety advocates and legal scholars discuss the impact of that decision and other measures that could be used to ensure public safety.
This meeting of the Senate Judiciary Committee will come to order. It's my understanding that Senator Graham is on the way and has asked us to start. We'll, of course, recognize him when he arrives for any opening statement he may have. Last week, I went to the Senate floor and paid tribute to a fallen Chicago police officer, Andre Vasquez Lasso, 32 years old. He was an immigrant to this country, became a U.S. citizen, volunteered for the Chicago Police Department, and served there for 5 years. He was killed protecting the same Southwest Side neighborhood he lived in. On March 1st, Officer Vasquez Lasso responded to a 9/11 call about a domestic violence incident. When he arrived on the scene, the suspect fled and a chase ensued. The suspect had a gun, and when he ran into an elementary school playground with children present, he turned and fired it 5 times. Kids were taking cover under slides and equipment they could find on the playground. Officer Vasquez Lasso was killed. For his funeral last week at St. Rita's Chapel, his wife Milena wrote, and I quote, "I wish I would have hugged you stronger that Wednesday morning, given you more goodbye kisses. If only I had known it was the last time I would see you alive." Every day, millions of Americans, like Officer Vasquez Lasso, dedicate themselves to protecting public safety and keeping our communities and our kids safe. Law enforcement officers, emergency responders, social service workers, community leaders, and teachers. These are increasingly dangerous jobs, in part because there are more guns than people in this country, and hundreds of Americans are shot every day. We owe it to these Americans to enact laws that will help protect them from being shot and killed. I believe that well-regulated firearm ownership to keep America safe is consistent with the Second Amendment. But we're up against a gun lobby that wants to strike down the gun laws on the books and stop new ones from passing. And that brings us to the Bruen case. Here's a brief video.
For more than a century. But the ruling tonight impacts not only New York, but 7 other densely populated states with similar laws where 80 million Americans live.
Shocking. Absolutely shocking.
In addition, the court established a new test for determining whether gun legislation is constitutional.
The old test had history in it, but it also considered contemporary costs and benefits. What the new test apparently does is say no consideration of contemporary costs and benefits, only history.
What the Supreme Court said, what Justice Clarence Thomas said is, you can't balance the individual right against public safety, against protecting against violence and crime. You can only look at, quote, history and tradition. The NRA and other gun rights advocates are going to be able to go into court and challenge hundreds of gun laws that have been upheld by the courts.
A federal judge in Texas has ruled it's no longer constitutional to ban people under felony indictment for buying guns.
Appeals court ruled yesterday that the government can't stop people who have domestic violence restraining orders against them from owning guns.
So bottom line, a lot of gun laws on a lot of jurisdictions could now be vulnerable with this new standard that the Supreme Court has come up with.
For the record, the Bruen decision came down the day before the Dobbs decision, which of course drew a lot of public attention. The gun lobby got what it wanted in the 2008 Heller case, a Supreme Court decision making clear that the Second Amendment is an individual right. But the gun lobby wasn't happy with more than 1,500 cases that implemented Heller in the lower courts. Why? Because those cases largely upheld the gun laws on the books from constitutional challenge. The courts said those laws passed muster under Heller's then two-step test that looked both at history and considered modern day ends and means. That was just too much for the gun lobby to take. So they went to work. They advocated aggressively to put justices on the Supreme Court who supported a history-based approach to Second Amendment challenges, so-called originalism, literalism. I discussed this approach with both Justice Kavanaugh and Justice Barrett at their confirmation hearings because I was concerned about what a conservative majority on the Supreme Court would do to our gun laws. And then, as I feared, the gun lobby worked to get a case before the Supreme Court, the Bruen case. Last year, the court's majority went further than necessary to decide the case and established a new, purely historical test for considering the constitutionality of gun laws. The gun lobby was thrilled. Wayne LaPierre of the National Rifle Association put out a press release. He called the Bruen decision a landmark win for the NRA that, quote, unequivocally validates the position of the NRA. That's the same Wayne LaPierre who sat in this room 10 years ago and testified before this committee that we, quote, need to enforce the thousands of gun laws that are currently on the books. But his Bruen press release didn't say that. It said, quote, many unconstitutional gun control laws remain in America. The NRA will continue to fight these laws. Now, after the Bruen decision, longstanding gun laws on the books are being challenged across the country, more than 100 cases so far. And under the new Bruen historical test, judges decide not whether a law reasonably protects public safety, but whether the law resembles laws that were in place in 1791 or in 1868. In the beginning, in 1791, of course, we were talking about muzzle loading muskets. I think about drawing that standard, legality and constitutionality based on 1791. And I think about last 4th of July in Highland Park, Illinois, when a deranged individual went on the roof of a downtown business and discharged 83 rounds in 60 seconds, killing 7 innocent people and injuring dozens of others, including paralyzing an 8-year-old little boy, Cooper Roberts. So it's no surprise to see decisions like the Fifth Circuit's recent Rahimi case. A panel of judges struck down a federal law barring those with domestic violence restraining orders from possessing guns. I can't square that decision with the actual danger that women and police officers face from armed domestic abusers. And I don't believe the founders of this nation would have wanted courts to simply ignore this danger when applying the Constitution they wrote. The chaos that the Bruen decision has caused was predictable. For 15 years, courts have been steadily applying the Heller decision to make reasoned judgments about gun laws on the books. Now, the Supreme Court has imposed a radical new framework under Judge Thomas's decision with barely any guidance to apply it, and plenty of opportunity for judges to cherry pick from history to engage in judicial activism in the name of originalism. The gun lobby saw Bruen as a landmark win, but it's a significant challenge for police, law enforcement, and the population of America when it comes to public safety. That's what we'll discuss today. We have a distinguished panel of witnesses that will examine where we go as we navigate Bruen's unprecedented upheaval of efforts to combat gun violence. I look forward to this discussion. I now turn to the ranking member, Senator Graham.
Thank you, Mr. Chairman. Well, number one, I think this is an important hearing to have. The role of the Second Amendment in average everyday life. Senator Cornyn worked in a bipartisan fashion to make some changes to background checks, putting money into the system to deal with folks that are a danger to themselves or others, to enhance public safety. So there's a bipartisan approach to some of these issues, but this sort of is the difference between the parties here, I would think. That America's Second Amendment was passed for a purpose. If you live in a kingdom, and the king rules, the first thing they want to do is make sure nobody can object and that you're pretty well defenseless. You have to ask yourself, why did we have a Second Amendment to begin with? Well, if you understand the history of the country, people fleeing England, where you couldn't say bad things about the king, you really couldn't express yourself. So the First Amendment allows you to speak openly and to worship the way you would choose, not the way the king would choose, and on and on and on, the right to assemble. The Second Amendment is to be able to bear arms. There are millions, 1.7 million times per year, people use firearms to defend themselves. I have a very long list of people who have been able to protect their family, their property, by having a firearm to ward off intruders and people who are acting aggressively toward them, particularly women. And Mr. Chairman, I'd like unanimous consent to put that in the record.
Without objection.
And what we're trying to do here, I think, is our Democratic friends are trying to make the argument that the Bruin-Heller cases, if they could, they would overturn those decisions. And I think people on our side are going to be unanimous in the idea that responsible gun ownership is part of American society. Guns are used every day to defend Americans, and people abuse the right to own a weapon. And I would hope we could find common ground to go after those who abuse the right to own a weapon, who act irresponsibly and enforce the laws on the books. So what we will be doing in response to this hearing is that I've introduced legislation, federal law, that would basically codify the Heller decision that the Second Amendment right to own a weapon is an individual right. And the Bruin decision having a different legal analysis about efforts to regulate guns, more back to the historical perspective of why we have the Second Amendment. As you want to overturn these decisions, we will want to reinforce these decisions. We found bipartisan support for the idea of background checks and trying to get guns out of the hands of people who are dangerous, Mr. Chairman. But we haven't had much success in finding common ground on increasing punishments for those who are involved in crime. We're talking a lot about fentanyl, but we haven't done much to deter it. All of us see the laws regarding sexual exploitation of children in need of upgrading. So what I hope we'll find is some bipartisan support to go after the criminal and reinforce America's safety. This is a very dangerous time in America, Mr. Chairman. The policies being pursued in the major cities in this country are not working on the drug front, on the public safety front. And here's the sad news. There's probably never been a more important time to be able to own a weapon than now. The threats to the average American are going up, not down. And at the end of the day, the Second Amendment is part of our Constitution. It is part of the fabric of this nation. There is bipartisan support to make sure reasonable gun ownership reigns, but there will be, on our side of the aisle, Mr. Chairman, a robust response to the idea of undoing the legal framework that has come out of the Supreme Court, because we believe now is the time to reinforce responsible gun ownership, not to undermine it. Thank you.
Thank you, Senator Graham. Today we welcome 5 witnesses. Let me introduce them. Our first witness is Ruth Glenn, President of Public Affairs National Coalition Against Domestic Violence. It's a project of the National Domestic Violence Hotline. Prior to joining this organization, Ms. Glenn had served at the Colorado Department of Human Services for 28 years, 9 of which she spent as a director of the domestic violence program. She is indeed a survivor of gun violence herself. Amy Swearer has appeared before the committee before. She is a senior legal fellow in the Heritage Foundation Edwin Meese Center, where her areas of scholarship include the Second Amendment, overcriminalization, school safety, and the intersection of mental health and gun violence. Eric Rubin, assistant professor at law at the SMU Dedman School of Law. His scholarship focuses on exploring the regulation of violence and weapons and how that regulation intersects with self-defense and Second Amendment. Rafael Mangual, did I pronounce that right? Good. Rafael Mangual is the Nick O'Neill Fellow and Head of Research for the Policing and Public Safety Initiative of the Manhattan Institute for Policy Research, where he writes on topics relating to police, crime, and incarceration, among others. And Stephen Lindley, who is the project manager for Combating Crime Guns Initiative at Brady. Before joining Brady, Mr. Lindley served in the National City Police Department in San Diego County and at the California Department of Justice. He has 27 years of law enforcement experience. I thank all of the witnesses for being here today. Each senator will have 5 minutes after you have 5 minutes for an opening statement. Could each of the witnesses please stand at this moment to be sworn in? If you'll raise your right hand, do you affirm the testimony you're about to give before this committee be the truth, the whole truth, and nothing but the truth? So help you God. Let the record reflect that the witnesses have answered in the affirmative, and we will recognize you in the seating arrangement that you've chosen. Ms. Glenn, you're first.
Good morning, Chair Durbin, Ranking Member Graham, and distinguished members of the Senate Judiciary Committee. I thank you for the opportunity to testify before you today on a critical issue, the impact of the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin on victims and survivors of domestic violence. As was stated, my name is Ruth Glenn. I am currently the Public Affairs President for the National Coalition Against Domestic Violence and the National Domestic Violence Hotline. I'm going to take my time to share with you why I do what I do, why it is important to speak to this issue, and how I hope to enable further understanding of the particular concerns for victims, survivors, advocates, and those that care for them when there is access to firearms by abusive, intimate partners. There was always a gun present during my 13 years of marriage. It was used as a tool to frighten me and control me. In one instance, when my son was 14 years old and he was struggling at school, my then husband aimed the gun at me, looked at our son, and said, "If you bring one more F in this house, I will kill your mother." I was so traumatized and terrified, I could hardly think. My experience was and is far from unusual. About 14% of women and almost 6% of men in the U.S. experience firearm threats from an abusive intimate partner. 43% of those women who have been injured by a firearm include being shot, pistol whipped, or sexually assaulted. I wish I could share with you that that was the extent of my experience, but it was not. I am fortunate to be among that 43%. Fortunate because I was almost another statistic. One of the people murdered every 7 hours by an intimate partner, mostly with firearms. An abusive male partner's access to firearm increases the risk of intimate partner femicide 5-fold. A gunshot is the most awful sound. The smell is even worse, especially up close. I remember those two blasts, each one distinctly. The first went under my scalp, the other skipped off my forehead. When a bullet hits you, you feel a stinging sensation, distinctly metallic, like being burned or getting an electric shock. I thought, this can't be happening. And then he shot me again in the arm. He drove away and left me for dead. This was pre-1994 when Congress passed the law prohibiting respondents to final protective orders from possessing firearms. I did not have the benefit of legal protections that are now afforded to survivors with protection orders almost everywhere in the United States. I say almost everywhere because those protections are being eroded by courts confused by the Supreme Court's ruling in Bruin. Bruin threw out the post-Heller two-part test that courts were using to assess the constitutionality of firearms laws and now requires courts to rule solely based on the historical tradition. To be blunt, the historical tradition when it comes to women in particular includes burning women at the stake as witches, permitting and even encouraging physical chastisement of wives, in other words, domestic violence, and turning a blind eye to rape and other forms of gender-based violence. Post-Bruin courts across the country have looked at the federal laws disarming adjudicated abusive partners and have come to dramatically different conclusions. While most courts that have considered the protective order prohibitor have upheld it, a 3-judge panel of the Fifth Circuit Court of Appeals found it unconstitutional in United States versus Rahimi. The legal implications of this ruling are limited, as it applies only to Texas, Louisiana, and Mississippi, and it does not apply to state laws. And it does not apply to the relief written directly into protective orders. But it is important to realize the confusion and concern that has resulted from the ruling. It is also important to note that the hotline, the National Domestic Violence Hotline contacts mentioning firearms in Texas, Louisiana, and Mississippi between February 2nd, when Rahimi was released, and March 9th, increased by 56.6% compared to the same time period last year. Given the general confusion, many respondents to final protective orders erroneously believe they are allowed to have firearms, and survivors may believe they can no longer rely on the courts for protection from abusive partners with firearms. The lack of historical laws restricting firearms access by domestic abusers is not evidence that such laws are unconstitutional. Rather, it is a reflection of the legally subordinate status and general disregard for the rights and needs of women in early America. Ultimately, we expect federal and state laws restricting firearm possession by adjudicated abusive intimate partners to be upheld. However, in the interim, some abusive intimate partners will legally access firearms they were previously forbidden from possessing, and some will use those firearms to terrorize or even kill their victims and others. The uncertainty created by Bruin has placed victims and their children in fear of their lives and created yet another barrier to safety. Thank you again for the opportunity to testify today, and I look forward to answering your questions.
Thanks, Ms. Glenn. Ms. Swearer?
Chairman Durbin, Ranking Member Graham, and distinguished senators. Last June in Bruin, the Supreme Court affirmed that ordinary law-abiding Americans have a right to bear guns in public for self-defense. It struck down New York's restrictive public carry framework, which required applicants to prove they had a, quote, proper cause to exercise their constitutional rights outside the home, a burden that was usually insurmountable. Additionally, Bruin rejected lower courts' use of a heightened scrutiny approach, an approach that they, not Heller, created, and that in practice allowed many courts to never meet a gun law that they couldn't find perfectly constitutional. Instead, under Bruin, judges must assess whether the challenged restriction is consistent with the nation's historical tradition of firearms regulation. After Bruin, some pundits and politicians immediately responded with hysterical fear-mongering about its potentially devastating public safety consequences. Even today, the title of this hearing presupposes, albeit with fewer theatrics, that Bruin is a thing from which the public must be protected. This is simply not true. Bruin's immediate impact on public safety is positive. For too long, states like New York told millions of citizens that their right to armed self-defense ended the moment they left their homes. Lawful gun owners are not the driving force behind criminal gun violence, and this is particularly true of concealed carry permit holders. At the same time, as I outline in much greater detail in my written submission, they play a significant but underappreciated role in crime prevention and crime interruption. Yes, good faith applications of Bruin will likely result in some favored gun control laws being struck down. To the extent that Bruin threatens certain laws, however, these are generally laws that weren't very good at protecting the public in the first place. And at the same time, it's undeniable that Bruin does not threaten many of the laws that are most effective at protecting the public. But in recent months, as some post-Bruin challenges have succeeded in lower courts, The opinions and reasonings therein have been grossly mischaracterized in the same way we saw after Bruin. I cover this handful of successful and still largely ongoing challenges in more depth in my written submission, but the recent Fifth Circuit decision in U.S. v. Rahimi is worth highlighting. As others have noted, the panel struck down a federal statute prohibiting gun possession for individuals subjected to certain domestic violence civil restraining orders, and the opinion has been widely and wrongly denounced as, in some respects, giving domestic violence abusers a license to kill and essentially preventing the government from doing anything at all about it. But let's review the facts underlying that case. The defendant there, Mr. Rahimi, is a despicable cretin that no sane, sober, moral, or prudent person truly believes should own guns. He violently assaulted his girlfriend, threatened to kill her, and shot at a bystander who witnessed the assault. The government quite properly charged him with several crimes. But then it released him, apparently believing that a civil restraining order instead of pretrial detention was the best way of dealing with this violent individual. Predictably, Mr. Rahimi soon thought, to hell with your restraining order, and committed aggravated assault with a deadly weapon against a different woman using a gun that he wasn't legally allowed to own, but obtained anyway. The government appears to have protected the public by releasing him again. And once again, Mr. Rahimi ignored the restraining order and its prohibition on his way to ignoring a lot of other gun laws about not shooting people. In a 2-month span, he shot at a guy he sold drugs to, he shot at a constable, he shot at the driver of a car crash he caused, fled the scene, returned in a different car and shot at him again, and then for good measure, fired a couple of rounds into the ceiling of a Whataburger restaurant. Let's assume, for the sake of argument, that the Fifth Circuit's interpretation of Bruin is correct, and the government can't charge Mr. Rahimi for violating his domestic violence restraining order because this is historically an inappropriate method by which to disarm people. Anyone who insists that this result somehow dramatically endangers the public either didn't read the case in good faith, does not understand the criminal justice system, or is very comfortable lying to your face. As the judges noted at length in that opinion, the government could have, completely consistent with Bruin, held Rahimi for pretrial detention after either time that he violently assaulted someone. It could have disarmed him as a condition of his pretrial release, a condition which he likely would have ignored as flippantly as he did his restraining order, but at least it would have been constitutional under Bruin. It can prosecute and convict him for at least a dozen serious crimes and incarcerate him for a very long time. If and when Mr. Rahimi is ever released from prison, every post-Bruin court agrees, and Bruin itself indicates that the government can continue prohibiting him from owning guns in perpetuity as a violent felon. Senators, do you see the problem here? It's not Bruin that will, as some critics have stated, get women killed. Both before and after Bruin, it's terrible criminal justice policies that get women killed. To any extent that Bruin limits the government's public safety options, it does so in a way that forces the government to use the far more effective tools already at its disposal to protect us from violent offenders. We are told all the time to respect the rights and needs of victims, as we should. We should respect them by detaining, arresting, and criminally prosecuting the men who harm them, and believe in them enough to allow them to defend themselves from these violent offenders when the government won't. I look forward to your questions.
Thank you, Ms. Swear. Professor Rubin.
Chairman Durbin, Ranking Member Graham, and members of the committee, thank you for inviting me to testify. My name is Eric Rubin. I'm a professor of law at SMU Dedman School of Law. Today, I'm testifying in my personal capacity. This committee is considering how to protect public safety after the Supreme Court's decision in Bruin. So it is important to understand what that decision did and the challenges that it presents for the lower courts. You just heard one view on Bruin and its aftermath. I've read the opinions, and I'm going to provide a different view. I will make 4 points. First, Bruin abandoned a mode of reasoning used for almost every other right and inserted a new test for evaluating the constitutionality of modern laws addressing modern guns and modern problems. In particular, Bruin held that in cases where the Second Amendment's text applies, courts must assess whether or not a modern restriction is consistent with this country's history and tradition. And to do that, the Bruin majority said that the government has to point to analogous regulations from the late 1700s or perhaps the 1800s. Litigants in courts, the court said, are to compare how and why modern and historical gun laws burden armed self-defense. This is a novel approach. It's different than the one that courts were using before the Bruen decision came down, and in fact, it's different from how the court itself usually evaluates constitutional rights questions. Second point that I'd like to make is that Bruen has introduced a substantial amount of uncertainty for Second Amendment doctrine with this new test. The lower courts have struggled to apply Bruen to modern laws such as those regulating 3D printed guns, large capacity magazines, or gun possession by domestic abusers. Bruen purported to constrain judicial decision-making through a test of historical analogy, but the post-Bruen case law highlights the risk that, in fact, Bruen has enabled judicial subjectivity and unpredictability. In different cases dealing with the same laws, or even within the same case dealing with a law, courts have pointed in opposite directions about what the Second Amendment means. Third, as the issue of keeping guns out of the hands of domestic abusers show, courts are struggling with how to compare modern laws to historical ones in light of the immense changes between the past and the present. What meaningful historical comparator can they be for the modern prohibition on guns in airplane cabins or on automatic weapons? Perhaps more fundamentally, what about modern laws that reflect broader social change, like prohibitions on gun possession by domestic abusers? The domestic violence focused gun laws highlight the challenge of basing today's constitutional decision-making on the legislative priorities of the distant past. The Fifth Circuit in the recent Rahimi case applied Bruen to strike down the prohibition on gun possession by people subject to domestic violence restraining orders. The court said that the record did not contain comparable gun laws from the framing era. But of course, there were not robust protections for the victims of domestic violence back in the framing era. Policymakers back then did not view women as the political or legal equals to men, and they did not prioritize protecting the victims of domestic violence through legislation. In fact, rather than focusing on protecting domestic violence victims, historically the law protected the husband's legal prerogative to inflict marital chastisement. But it would be absurd to think that the Constitution today condemns us to that same view. Fourth, and finally, despite the initial disruption that is caused, Bruen does not mean the end of reasonable gun policy. We have a long tradition of gun regulation in this country, and the justices in the Bruen majority said that properly interpreted, the Second Amendment still allows for a variety of gun regulation. The major challenge after Bruen is how to compare historical gun laws to modern ones in light of changed circumstances. The Rahimi court, for example, recognized that historical laws disarmed various groups of people viewed to be dangerous, but it then construed those historical laws narrowly and concluded that they could not serve as analogs for the modern laws regulating gun possession by those subject to domestic violence restraining orders. But other courts have taken a different message from those same historical gun laws. In a case called Cantor v. Barr, then Judge Amy Coney Barrett looked at the same laws that were considered by the Rahimi court, but she reached a different conclusion about their meaning. She wrote, quote, "History is consistent with common sense. It demonstrates that legislatures have the power to prohibit dangerous people from possessing guns," end quote. The central challenge for the Second Amendment today is ensuring that history and common sense do not part ways. Thank you for the opportunity to testify, and I look forward to your questions.
Thank you, Professor. Mr. Manuel.
Good morning, Chairman Durbin, Ranking Member Graham, and members of the committee. I'd like to begin by thanking you all for extending to me another invitation to testify before this body on what is perhaps the single most important policy issue of our time, public safety, especially gun violence. My overarching point this morning is straightforward. When it comes to the important issue of public safety, our most pressing problem is not the possibility that more law-abiding citizens will now be able to carry firearms for self-defense in the small handful of states that didn't already allow them to do so prior to Bruin. It's that in so many parts of the country, legislative and administrative policy choices have exacerbated the risks associated with failing to arrest, prosecute, and meaningfully incapacitate high-risk, high-rate criminal offenders. As such, the focus of policymakers hoping to stem the tide of resurgent violent crime should be on identifying and plugging the holes created or made larger by recent depolicing and decarceration efforts. Failing to do so will inevitably lead to tragedy, as it has in so many cases already. One of those cases is the shooting death of Kiara Hudson Benefield in upstate New York last year. The 40-year-old mother was taking her kids to school when police and prosecutors allege she was fatally shot in the head by her husband. Her husband was released on his own recognizance before the shooting. That release came after being charged with savagely beating Kiara Hudson, an assault that was captured by a home security camera and shared with the authorities. And the release occurred despite the defendant having been paroled in 2015 after serving time for the armed kidnapping of an ex-girlfriend and escaping from a correctional facility. New York's bail laws required release and prohibited the judge from considering the danger that this man posed to his wife or the community. Perhaps the most tragic part of this story is that Kiara was so certain about the risk that she faced that she was reportedly wearing a bulletproof vest at the time she was killed. Instead of the safety that she needed, all the court would offer Hudson Benefield was a piece of paper containing an order of protection. Unfortunately, data from multiple sources suggest that when it comes to domestic violence, shootings, homicides, stories like the one I just told are all too common. A report published by the Indiana Criminal Justice Institute reported that the 3,036 individuals convicted of domestic violence in 2017 had a combined total of 15,396 prior arrests. A study done by the University of Chicago Crime Lab found that on average, those arrested for a shooting or homicide in that city in 2015 and 16 had 12 prior arrests. Nearly 1 in 5 had more than 20. This measure is in line with recent remarks from Washington, D.C. Metro Police Chief Robert Conti, who told members of the media earlier this month that, quote, the average homicide suspect has been arrested 11 times prior to them committing a homicide. What all of this tells us is that the laws that we have on the books regarding firearms restrictions, or any other criminal law for that matter, are no good to us unless we have the wherewithal to see to it that those who violate the rules are held to account in a way that actually protects public safety. And this is where the focus of policymakers should lie. We must be seeking to find and, where necessary, create opportunities to maximize the incapacitation benefits that attend the incarceration of bad actors. Actively supporting efforts to cut down on those incapacitation benefits is simply incongruous with calls for more gun rights restrictions as a means to pursue public safety gains. And yet cutting down on incapacitation is precisely what recent criminal justice reforms have achieved over the last decade plus. And these reforms, individually and collectively, have reduced the likelihood of arrest, prosecution, and/or incarceration for many criminal offenders, as evidenced by the 24% decline in the nation's prison population and 15% decline in the nation's jail population between 2010 and 2021, as well as a 25% decline in arrests between 2009 and 2019. None of that makes us safer, especially not those stuck living in the small slices of the country where crime concentrates. The downside risk associated with the push for decarceration and depolicing will be borne disproportionately by the very same people living in the pockets of concentrated gun violence. And this was made crystal clear by a study published last year and reported on by the Wall Street Journal, showing that the 2021 firearm homicide victimization rate approached 60 per 100,000 for Black men, reaching its early 1990s peak, which is almost double what it was just 10 years ago. The white male rate stood in the single digits. America's gun violence problem has gotten significantly worse in recent years, and that should concern us all. The reversal of the progress made over the 1990s and early aughts has hit a very small slice of America in a very big way. Now, I'm encouraged by this committee's desire to engage with this problem, but I urge its members to consider that the policies most urgently in need of change are those that have lowered the transaction costs of committing crime or raised the transaction costs of enforcing the law. At the end of the day, rules without the means or will to enforce them are little more than empty threats. And for those stuck living in America's most dangerous neighborhoods, they're broken promises to boot. Thank you, and I look forward to your questions.
Thank you, Mr. Manuel. Mr. Lindley.
Chairman Durbin, Ranking Member Graham, and distinguished members of the committee, thank you for the opportunity to testify before you today. My name is Steve Lindley. I've spent my career in the service of public safety. For nearly 3 decades, it's been my honor to serve in law enforcement, starting as a cadet, working my way up to a detective, sergeant, and then a special agent. I made it to the upper ranks of the California Department of Justice and spent nearly a decade as the chief of the Bureau of Firearms. Today, I work with the Combating Crime Gun Initiative at Brady, one of the nation's oldest gun violence prevention organizations. I serve as a senior technical advisor on firearm issues, California gun laws, and the source of diversion of trafficked firearms. California was a very different place when I joined the police force in 1990. At the National City Police Department, we responded to shootings every night. Everyone in the streets had a gun, and by 1993, California had a firearm homicide rate that was 46% higher than the national average. Our streets were awash with guns and victims, and every day my colleagues and I put our badges and our vests on and hoped for the best. Almost every cop has a moment when gun violence really hits home. For me, it was in 1992 when I held a 16-year-old boy and watched the life drain from his eyes. He got into a fight over a girl, a fight that happens every day in our country, sometimes hundreds of times. Except during this fight, one of the kids had a gun. What should have ended with a bruised ego and maybe a black eye ended with that boy coughing up blood all over me. He asked if he was going to die, and I wish I could have told him he was going to be okay. I wish my story was unique, but it represents a bigger problem that requires more than thoughts and prayers. Between 1989 and 1991, California took its initial steps to address gun violence, passing an early assault weapons ban, comprehensive background checks, and prohibitions for violent offenders. Nationally, there was also a reckoning of gun violence, with Congress passing the Brady background check bill and assault weapons ban. California built in these laws, establishing a reasonable framework of gun laws, and it worked. In the last 3 decades, our firearm homicide rate was cut in half. Today, California remains the biggest state with many of the country's largest cities, but our gun death rate is 36% lower than the national average and 7th lowest in the country. It could have been much lower, but the most recent statistics from ATF shows that tens of thousands of guns traced to crime in California come from other states. Needless to say, we also share the national burden of mass shootings, most recently Monterey Park and Half Moon Bay. However, our laws, especially around assault weapons, make it much more harder for mass shooters to access the most deadly firearms. Californians are 25% less likely to die from a mass shooting than people in other states. We have some of the strongest gun laws in the country, and they're working. But rest assured, the Second Amendment is alive and well in California. We have more civilian-owned firearms than most other states. More than a quarter of Californians live in a gun-owning home, and Californians purchased almost 1 million firearms last year. This past summer, the Supreme Court upended California's longstanding framework with the opinion in Bruin. And today, California's assault weapons ban, high-capacity magazine ban, age restrictions, and ammunition background checks are all at risk. Federal laws are also at risk, including those passed by this body last year. In courts across the country, we're seeing confusion and activism in applying the new Bruin standards. States are being forced to reconsider every law as if it was written in 1791, when muzzle-loaded muskets and pistols were the only firearms available to the public. Evidence shows that laws protect public safety while representing Second Amendment rights. I'm neither a lawyer or a historian, but what I can tell you after nearly 30 years in law enforcement is that if gun safety laws continue to be struck down, it'll be harder for law enforcement to protect public safety and will make their jobs far more dangerous. After nearly 3 decades in law enforcement, I can also say that we cannot incarcerate our way out of this problem. We tried that and it didn't work. While we all agree we need to enforce the law, we do not devote enough attention to the upstream source of guns being trafficked into our communities. Guns do not grow in trees, and they do not magically appear on our streets. In addition to my work at Brady, I'm also a high school teacher. My students worry about 1 million different things these days. Near the top of that list, are they going to be shot on the way to school or while at their desks? As I watch over my students, I'm constantly reminded of that 16-year-old kid who died in my arms. A kid who, today, could be in my class. He lost everything he was and everything he could have been. I look at my students and I wonder if I will lose one of them. Will one of them lose their future to senseless gun violence? Will my daughter? That's a question that terrifies me every day, a question millions of parents ask themselves every day. Thoughts and prayers are not enough. Action is needed. Thank you for the time today and look forward to your questions.
Thank you, Mr. Lindley. We'll start the questioning. I want to thank you personally, 27 years in law enforcement, and I want to thank all the men and women in law enforcement. We know that they are under close scrutiny and living lives which subject them to dangerous situations on a daily basis to protect us, our neighborhoods, and our homes. But let me ask you this point blank. We're in mourning in Chicago because 2 weeks ago today, an officer responded to a domestic violence incident. A man with a gun chased that man who turned on him and killed him in a playground of a school in Chicago while the children around were cringing in fear. How often do domestic violence incidents, have you run into domestic violence incidents in your practice of law enforcement?
Thank you for the question. Law enforcement is one of the most difficult jobs I think we have in this nation. We ask a lot of our officers day in and day out. And one of the most unpredictable situations that they're called to deal with is domestic violence. They're going into a charged, emotionally charged situation, and not knowing what the basis of it is into a situation that may have taken years to come about. Also, you look at the different type of weapons inside the house. You have firearms, you have bats, you have knives, you have frying pans. It is a very difficult situation, and lots of injuries to law enforcement and injuries to the public come about from domestic violence situations.
So one of the witnesses here says, well, it's okay, Rahimi, if you accept it, that person would have a gun, they'll probably break some other law that they can be prosecuted. Does the gun presence of a firearm in a domestic violence dispute make it more dangerous for the police?
Absolutely. Firearms in the house when law enforcement is there in an emotionally charged situation, unless the situation is completely controlled, which is difficult for law enforcement to do these days, makes it very dangerous for them.
Professor Rubin, let's follow what the court has decided and see if you can help me understand it a little better. They've decided that they can't find, and Rahimi, they decided they couldn't find an analogy to removing a firearm from a person who was under a domestic violence protective order. And so as a consequence, they struck down the applicable law in that situation. And yet when it comes to the firearms themselves, they don't go back to 1791 and ask the obvious question. What did the founding fathers have in mind when they used the word arms? They seem to have expanded to almost anything. I used the example before in Highland Park at a 4th of July parade with a man on the roof of a building firing off 83 rounds in 60 seconds, killing 7 people, injuring dozens of others. There wasn't even a weapon imaginable in 1791 that could do that. How do they make that leap when it comes to arms to include that type of assault weapon?
Thank you, Senator. So this is one of the challenges and the questions that comes up after Bruin is how can we make sense of our historical gun laws in light of the vast changes, including gun technology and also in terms of our moral sensibilities. We had a blinkered moral sensibilities when it came to gendered violence back in 1791. And one of the points that I fleshed out a bit in my written testimony is that if we're going to be approaching what counts as an arm at a high level of generality, and allow that to evolve with the times, then we certainly need to find ways to likewise allow our regulatory frameworks to evolve as well to deal with modern problems today.
Ms. Glenn, you have a personal experience with this, which is chilling to think what you went through as a victim of domestic violence. What do you think about the argument that someone with a gun in a domestic violence episode is likely to break some other law that they can be prosecuted for, and that's good enough?
Thank you so much for the question. It certainly is not good enough. Without understanding the dynamics of domestic violence, and when there is a domestic violence situation in which an abuser has a firearm, and the escalation that occurs. And if you don't understand the dynamics of domestic violence, sometimes that's all that's present is the domestic violence situation. Waiting for prosecution or charging in that particular instance is unreasonable. Protective orders are built to help the victim provide themselves with protection. Removing the firearm is also that part of ensuring that safety and that they can be safe.
Thank you. Senator Graham?
Thank you. Ms. Swear, let's revisit, is it the Rahimi case? Is that the right name?
Yes, sir, I believe so.
Okay. Let's see what is the most compelling thing to learn from that case. How many times was this gentleman involved with shooting at people?
I'm not sure in total, but it seems like at least 6 or 7.
Okay. And he was released based on what charge? He was facing a charge and released?
The first time he was facing at least one felony domestic violence charge and at 2 others. I'm not sure whether they were misdemeanors or felonies under Texas law.
Okay. Is it pretty fair to say that this guy should not have been out on the streets?
Absolutely not. He was very clearly a danger to both specific individuals and the public at large.
Mr. Manguel, is this a common problem where our criminal justice system has a revolving door when it comes to people who are exhibiting violent behavior?
It most certainly is a common problem, and one that is a long-standing problem as well. I mean, one of the statistics I didn't get a chance to get to was that between 1990 and 2002, the Bureau of Justice Statistics reported that over a third of individuals convicted of violent felonies were either out on probation, parole, or pretrial release at the time of those offenses. As our criminal justice system has gotten softer, that problem's only gotten bigger.
So when you look at what America is facing, would you agree with me the best thing we could do as a nation is to make sure that our parole laws and our attitude toward violent criminals is changed so that they are not out hurting people, they stay in jail?
I think that's exactly right. I mean, one of the biggest challenges that we currently face, as evidenced by the data on the role that repeat offenders play in serious gun violence, is that we are systematically failing to draw and enforce a line as to how much repeated criminal conduct we are willing to accept and tolerate.
Well, if your proposition is true, America would be responding in a certain way. Do you realize, Ms. Swear, that from 1991 to 2019, the number of guns in America number of weapons owned by Americans has doubled?
I am aware of that. Yes, Senator.
Do you are aware of the fact the number of concealed carry permits have increased by 7-fold?
I know it has increased exponentially. I will take you at your word that it's roughly 7.
Are you aware that between 2019 and 2020, 58% increase in gun purchases by African Americans, 43% increase by Asians, 46% increase in purchases by Latino Americans, 40% of those purchases were made by first-time gun buyers? Are you aware that from 2005 to 2020, a 77% increase in gun ownership by women, and that from 2019 to 2020, a majority of people buying guns were women? Are you aware of all that?
Yes, Senator, I am.
Why do you think that's going on?
It's because there are a lot of Americans, specifically, as you mentioned, women and ethnic minorities who, a lot of them for the first time in their lives, beginning in the last couple of years, looked around at the state of reality in this country with sort of widespread and issues with policing, with.
Well, let's just stop there for a moment. Mr. Lindley, you've been a police officer. Thank you for your service. How's morale among police in America, generally speaking?
Thank you for the question, Senator. I think overall morale is decreasing.
Yeah. And there are probably a lot of reasons for that, but it's harder to get people into law enforcement now. And I'd like to work with people to try to change that. Mr. Rubin, do you agree with the Heller decision that interpreted the Second Amendment to be an individual right? Was that a good legal decision?
Yes, sir.
You do?
Yes.
Yeah, thank you. Ms. Glenn, your experience was terrible. your husband, former husband, had been charged with armed robbery. Had he been convicted of armed robbery, or I don't know, make sure I got.
Yes, many years before the incident. Yes.
Okay, and he had actually been charged with kidnapping you too
Yes.
before the shooting.
Months before the incident.
Yeah. So I guess here's my point. Senator Cornyn has shown the way to work on responsible gun ownership limitations. I don't think there's anything in this case that says common sense doesn't prevail. But this Bruin case and Heller case are important in my view. Mr. Chairman, it reinforced the idea that the Second Amendment is there for individuals and that individuals have a right to defend themselves in a responsible way, even outside their home. So what I would hope this committee could do is end, to the extent possible, the revolving door policies that allow people time again to the streets, hurt their fellow citizens. In this situation, I would just add in conclusion, the reason so many people are buying guns is because they've lost faith in their government to protect them.
Thank you, Senator Graham. Senator Whitehouse.
Thank you, Chairman. Thank you to the witnesses for being here. Professor Rubin, the history and tradition of fact-finding in the American judicial system is that it's done at the trial court level. And where the rare challenge, successful challenge to the very tough, clearly erroneous standard is made on appeal, then an ordinary way to resolve that is to send the case back to the district court for fact-finding where fact-finding belongs. I've had a hearing in my courts subcommittee on this Supreme Court's recent penchant for appellate fact-finding. Some of the prominent cases have been Shelby County, where they made the finding that nobody had anything to worry about from the freed legislatures, that conditions had changed. And then, of course, immediately you saw a case come up in which federal judges said this is targeted with surgical precision at minority voters, completely discrediting the spontaneous fact-finding by the court. Citizens United was another one. They said that don't worry about it. All the unlimited spending we're going to unleash is going to be independent of candidates, and it's going to be transparent. And a couple of $1 billion of dark money, transparent funding later, we know perfectly well that that fact-finding was false. So this seems to be an increasing trend. And I noticed in the Bruin case, there was a lot of fact-finding done in the context of defining what the true history and tradition were. A lot of historians to look at that and said that is junk history, that is not real. It had not come up through any kind of an adversarial process. It was not tested in the different layers of review. It was just made up by the Supreme Court justices. Could you talk a little bit about the dangers of appellate fact-finding in terms of how it permits ambitious and activist courts to run a bit wild if they're not constrained any longer to facts found history and tradition of judicial fact-finding in lower courts and through adversarial process?
Thank you, Senator. So Bruin has transformed the way that litigation looks, transformed from before Bruin was decided when a more conventional approach applied. Now, one of the things that we're seeing is that historians are getting retained by the parties. In fact, courts themselves are asking litigants whether or not they should retain their own independent historian to help them parse the historical facts. And one of the challenges that comes up, as you mentioned, is what happens on appeal, especially if a court on appeal is doing historical fact-finding that subsequently is determined to be erroneous. Are lower courts then bound by that erroneous historical determination when ordinarily there would be a route to appeal and challenge it. So this is transforming the way that litigation is looking.
I think it needs to transform a good deal because if you have an appellate decision that stands on what events have proven to be utterly false facts, and the appellate court hasn't gone back and cleaned up its clear error, then it becomes incumbent on the lower courts to take a look at that and see if it really makes sense. Because Marbury v. Madison says that it's the job of the Supreme Court to decide what the law is. It has no particular expertise with respect to the facts. In fact, it's probably the worst part of government to make decisions about the facts, given the constraints on briefing and so forth. So thank you for that observation. The other thing that was notable about Bruin was that 12 NRA-funded amici showed up, and the funding dispute have been a continuing source of frustration. The Judicial Conference is now looking at that, and I hope we'll be putting out a report fairly soon. But what is the danger if other parties and the public and the judges don't have a true and accurate description of who is really behind an amicus group that shows up in court, particularly as regards coordination of multiple amici?
Senator, I think that it's important to understand who is filing different briefs, just in terms of assessing whether or not there are any particular biases with the briefs that are getting filed.
Motive matters, right? Thanks, Chairman.
Thank you, Senator. Senator Grassley.
Thank you, Mr. Chairman. Thanks all the witnesses for being here to discuss this very important issue. I'm going to start with Mr. Mangual. Last year, I held a field hearing in Iowa for the docket chair with Chairman White House. At that hearing, the Iowa Department of Public Safety Commissioner said that 42% of the murders that occurred in Des Moines in the last 2 years had a tie to drug trafficking. So I'm interested in your view on a national basis. How does drug trafficking factor in to increase that we've seen in violent crime?
Well, I think drug enforcement certainly can play an important role in the provision of public safety. And one of the main reasons for that is that there's a substantial overlap between people involved in the drug trade and people who are driving the serious kinds of gun violence that we're here to talk about today. One of the statistics that always comes to mind on this point is a statistic out of the city of Baltimore, which in 2018 reported that of the about 118 homicide suspects identified from the year 2017, 7 in 10 had at least one prior drug arrest in their criminal history. If you look at the recidivism data at the national level, the Bureau of Justice Statistics often reports on longitudinal analyses looking at the rate of recidivism for people who are incarcerated primarily for drug offenses. 75% of them will be rearrested for at least not one non-drug offense, and more than a third will be rearrested for a serious violent offense specifically. And so if you talk to law enforcement agencies, I think what they'll tell you is that they view drug enforcement as a way to pretextually attack violent crime. Taking that tool off the table or minimizing it, as has been done through criminal justice policymaking over the years, I think can be significantly detrimental to our overall strategy to reducing gun violence.
Also, to what extent is the rise of violent crime connected with gangs or organized criminal activity?
Well, gangs significantly drive violent crime numbers, at least gun crime in the sort of pockets of concentrated violence that I talked about in my testimony. If you look at places like the south and west side of Chicago, for example, the southwestern district of Baltimore, certain precincts in cities like Detroit and St. Louis, what you'll see is that gang members or crew members are significant drivers of the violence. That's true in my home city of New York as well. Identifying those individuals and singling them out for prosecution can be an effective strategy. There's one study done by an individual named Aaron Chalfin, who's a criminology professor at the University of Pennsylvania, on precision policing in New York City. And what that study found was that gang sweep prosecutions in New York City were responsible for a significant, I think almost 30% reduction in shootings over the time period of the study, which shows that if you are able to target your law enforcement resources at the small number of actors in the tight-knit social networks that drive gun violence, you can have an outsized impact on the safety picture.
Yeah. Last fall, the FBI released its 2021 crime statistics. Those statistics showed that the number of murders increased from 2020 to 21 by 4 3/10%. That's on top of the 29% increase 2019 to 2020. So to you, Mr. Manguel, that's a steep increase in violent crime. But isn't it true that the rates of violent crime have affected some communities more than others? And as an example, African-American community.
That's exactly right. I mean, the homicide victimization rate for African American males is about 10 times that the rate for their white male counterparts. And in my home city of New York, the New York City Police Department has been keeping data on gun violence and gun violence victimization since at least 2008 in a systematic way. And every single year for which we have data, a minimum of 95% of all shooting victims in that city are either Black or Latino. And I can assure you that Blacks and Latinos do not constitute anywhere close to 95% of New York City's population. And if just to really hit the point home on the geographic concentrating, which is really not. In any given city in America, somewhere around 5% of street segments will see about 50% of all the violence. In my home city of New York, about 3.5% of street segments see 50% of all violent crime. About 40% of street segments don't see any violent crime whatsoever. I mean, just to really bring the point home with an example out of the city of Chicago, the 10 most dangerous neighborhoods in that city in 2019 had a collective homicide rate of 61 per 100,000. Collectively, the population of those neighborhoods was on average 95% Black and Hispanic. If you take the 28 safest communities in that city that same year, the homicide rate was less than 2 per 100,000. So this is a problem that disproportionately affects some communities more than others, and we should keep that in mind. And it should also be a source of comfort to know that we don't have to take a dragnet approach to enforcement to do the job well. We can target our approach because data tell us very clearly that a small number of individuals drive this problem.
Mr. Chairman, could I ask a very short question of Ms. Yeah. Can you tell us what the fastest growing group of gun owners in America is?
My understanding, Senator, is that that is specifically Black women.
Okay. Thank you, Mr. Chairman.
Let me add, since we're displaying our expertise on Chicago, that I know a little bit about that. And I would say poverty is an important overlay in this question. And it applies to Hispanic neighborhoods as well as Black neighborhoods. And I also think that if you're looking at the general population in the city of Chicago, you'll find that violent gun crime is now reaching beyond those areas into other neighborhoods because of social media and many other aspects. So there's a lot more to the story than what you just said. Senator Hirono.
Thank you, Mr. Chairman. In 2020, Hawaii had the lowest gun death rates and the third low rate of ownership in the entire country. Prior to Bruin, Hawaii police departments had only issued 4 licenses to carry in the past 2 decades. Following the court's decision, however, police departments across all counties in Hawaii have begun issuing licenses. As of December
strategy about how you're going to address the gun issue, knowing that Republicans aren't going to bring your favorite proposals to the floor?
Yeah, well, excuse me. Well, this is another example of how extreme they are, because it's not Democrats' favorite proposals. These are proposals, whether it relates to extreme risk protection laws or universal criminal background check legislation, or even the assault weapons ban, because we should not have our streets flooded with weapons of war that aren't used to hunt deer. They're used to hunt and slaughter children in classrooms that we've seen. These gun safety proposals actually have broad support amongst the American people. But the reason why we haven't been able to address them is because of the
of the extreme MAGA Republican House majority. That is very unfortunate. And yes, we're having ongoing conversations about how to continue to highlight the fact that we stand with the American people in wanting to do something decisively on gun safety, and the fact that the extreme MAGA Republicans stand with the MRA.
So you haven't settled on a strategy?
We're having ongoing conversations about different ways to continue to elevate the issue. The strategy is we are going to continue to focus on pushing for common sense gun safety legislation with the fierce urgency of now.
Do you want to discharge the petition personally?
Well, there are a variety of different things that can be done, hopefully to make clear to the American people that we are pushing for action. A discharge petition is one of the vehicles that may be available to us, but we'll continue to have discussions and see where we land. Thank you, everyone.
Thank you.
December 2022, Hawaii County has issued 89 concealed gun licenses and Maui County has issued 18. Between 50,000 to 60,000 people are expected to apply for a concealed carry permit in upcoming years. State and local officials have expressed concerns that lax gun laws may lead to a rise in violent crime. Consequently, county police departments have implemented stronger requirements for applicants seeking licenses to carry. State and local legislators have also, including an enacted law in Hawaii County designating sensitive places, such as churches, where firearms are prohibited. However, gun owners have stated their intent to challenge these gun legislations in court. In September 2022, the National Association for Gun Rights, NAGR, filed a lawsuit against the state of Hawaii seeking to overturn the state on assault pistols and large capacity magazines. The NAGR is seeking to challenge the constitutionality of these laws under the court's new framework in Bruin. The organization had filed 6 other lawsuits against state and cities with assault rifle or large capacity magazine bans. So a question for Mr. Lindley. Do you think that the concern over the thousands and thousands of applicants who will now apply for licenses in Hawaii and that this could lead to a rise in violent crime, is that a misplaced concern? Do you agree with the concern of law enforcement in Hawaii?
I do agree with those concerns, Senator. If you just looked at more guns equals safety, there's over 400 million firearms in the United States. If that was the case, we should be the safest country in the world. So more guns is not the answer to safety.
I agree with you. And the statistics I pointed to in Hawaii, where we have some of the strictest gun safety laws, and there is a cause and effect as to the use of guns in Hawaii in violent situations. Ms. Glenn, you have spent almost 30 years as an advocate for domestic violence victims and have testified today on the impact of Bruin on intimate partner violence. Just last month, the Fifth Circuit, in the first major case to apply Bruin, found that portion of the Violence Against Women Act that prohibited the possession of firearms by those subject to certain domestic violence restraining orders violated the Second Amendment. This kind of restriction was a common sense kind of restriction on violent abusers. How will interpretations of Bruin like this one in the Fifth Circuit make it harder to protect victims and survivors of domestic violence?
Thank you so much for the question. I think we go back to my written testimony, which is there has to be some type of protection that is allowed before the violence escalates. So having a protection order that says that I can have a firearm removed from the situation so that I am safer is very, very critical.
Well, I'd say under Bruin, maybe there's no historical basis for removal of a firearm in those kinds of circumstances. Professor Rubin, I really found it instructive that you said that this decision is transforming the way litigation is looking, and historians are being retained in cases. Justice Barrett and Bruin observed that the flaw of a historical approach to the Second Amendment and in the interpretation of the Constitution is that originalism is far from scientific. I would agree with that. And sadly, though, she went ahead and agreed with the majority opinion in that case. So I wanted to ask you, Professor Bruin, in the wake of Bruin, you examined New York's proposed legislation to require gun owners to have express permission from property owners to carry guns onto their private property, including homes, restaurants, offices, and entertainment venues. Do you think a law like that would withstand a Bruin challenge?
So, Senator, that law is currently the subject of litigation, some adverse decisions currently on appeal. There's a fundamental right to keep and bear arms, but it's important to recognize that there's also a fundamental right to private property. And there's nothing in the Constitution that says that the right to keep and bear arms has to trump the private property rights of other people. And so one of the things that law in New York does is it switches the default. Private property owners always have the ability to exclude people who are carrying gun if they don't want that person on there. All it does is switches the default about who has to ask who about the private property owner's preferences.
I applaud New York for their approach. And by the way, you know, before Heller, which was a 2008 decision, there was no explicit, in my view, right for individuals to own guns and also to own whatever the guns they wanted. Heller is a 2008 decision. How did we get along with the Second Amendment before then, I say? Thank you, Mr. Chairman.
Thanks, Senator Rono. Senator Cornyn?
Thank you, Mr. Chairman, and I appreciate a legal seminar as much as anybody. But what I'd like to see, whether we can get some agreement on some basic principles. First of all, Ms. Swearer, do you believe a law-abiding citizen is a threat to public safety because they exercise their Second Amendment rights to keep and bear arms?
Statistically, no, Senator. Law-abiding citizens are not a threat to public safety. They are overwhelmingly not responsible as a driving force behind criminal gun violence.
Well, one area that we're in this very, what can be a controversial topic, where I think we've been able to find some consensus is on the importance of background checks to make sure that people who are prohibited under existing law from purchasing or possessing firearms, namely people with criminal convictions, people with mental health commitments and the like. This has been one area where we have been able to find some consensus. A couple of years ago, we passed a bill called Fix NICS, which was after the Sutherland Springs shooting, where the Air Force had failed to upload criminal convictions of the shooter into the NICS background check system. Several of us went recently to Clarksburg, West Virginia, to see how the FBI is conducting the background check system, and it is pretty impressive. More recently, as the chairman mentioned, or others mentioned, we were able to find some common ground on the Bipartisan Safer Communities Act. Again, in an area where it's hard to find much common ground. But I just want to update my colleagues on exactly what has happened so far with this, for example, the enhanced background check for gun purchasers between the age of 18 and 21. Unfortunately, it's a cohort of individuals who are disproportionately impacted by this profile, or disproportionately part of a profile that characterizes shooters from Adam Lanza at Sandy Hook,
to the shooter in Uvalde more recently. Using the enhanced background check authority that Congress passed in the Bipartisan Safer Communities Act, so far, the background check system has identified 101 potential transactions where juvenile records, which are now subject to the background check system, have disclosed individuals that have are either convicted felons, drug users, or those with mental health adjudications who otherwise, had they been an adult previous to that statute, would have already been prohibited from purchasing a firearm. At the same time, 98.5% of the National Instant Criminal Background Check transactions are unaffected by the Bipartisan Safer Communities Act. So it was focused on that cohort, that age cohort that was disproportionately represented in some of the mass shootings that we've seen around the country, and it seems to be working. Likewise, some of the additional penalties that we included for straw purchasing of firearms and trafficking in firearms has led to 30 indictments so far, just in the brief few months it's been in effect. Indictments of gang members, cartel members, and other violent criminals. Mr. Manguel, let me ask you, I thought you made a really important point about how what parts of the communities are affected by gun violence and others that are not as affected as dramatically, and how communities of color and where there's lower income levels are disproportionately affected. You're familiar, I'm sure, with Project Safe Neighborhoods, are you not?
No, I don't think I am.
Okay. Well, Project Safe Neighborhoods is a targeted effort, which you seem to allude to there, where you go after targeted enforcement of convicted felons and people who cannot legally possess firearms, and you prosecute those cases using the minimum mandatory minimum standards under federal law to keep those individuals off the street. Is that a sort of targeted effort that you think might address this, what you identified in terms of where this is a big problem and where it's not as big or as urgent a problem?
I do. The kind of prohibited possessor laws that you're talking about that carry those significant sentences, I think can be a really important tool in a targeted approach to addressing the gun violence problem.
Thank you.
Thank you, Senator Cornyn. Senator Welch.
Thank you, Mr. Chairman. I thank the witnesses. You know, this question of gun violence is really being affected by changes in analytic approach by the Supreme Court. The changes in the analytic approach by the Supreme Court, in my view, has resulted in a significant threat to the legislative prerogatives and a imbalance in the checks and balances that are so essential to the well-being of our democracy. The historical approach that the Supreme Court is taking to many, Senator Whitehouse, of course, is the leader of the subcommittee, has been a leader on this, is, in my mind, is creating the significant, not potential, but the significant reality of the court essentially bootstrapping opinions to get to the result that it wants, and interfering in the legislative prerogatives and responsibilities that a legislature has to protect the well-being of its citizens. This historical approach I want to ask you about, Professor Rubin, you've been talking about it, but it is leading to some of these anomalies where things that the courts, lower courts, are deciding in response to this seem to me to make no sense whatsoever. I'll just give a specific example. In the United States v. Price, a district court held that a federal law prohibiting possession of a firearm with an altered or obliterated or removed serial number, something's essential in law enforcement investigation, was unconstitutional. And the reason was we didn't have serial numbers that weren't in common use in 1791. And the way I react to that is the court is the ultimate legislative body when it has the capacity to essentially wave away the rights of the people of this country through their elected representatives to address challenges that it faces as a society. Could you comment on that?
Sure, thank you. So you talked about legislative prerogatives, and indeed during this hearing, I've heard a lot of comments about policies that, in some people's opinions, work or don't work. And traditionally, conventionally, that was what legislative bodies focused on. And one of the problems and concerns with the Bruin opinion is that the Bruin opinion said that, in fact, it's not modern legislative priorities that are most important for assessing the constitutionality of modern laws, addressing modern problems. It's the legislative priorities of legislative bodies over 200 years ago. Now, this still shouldn't cause all gun laws to be struck down. The court set forth some standards, but they're simply not specified enough to provide a lot of guidance. And so one of the things that we're seeing in the lower courts, including in the Price case and others, is that courts are emphasizing or de-emphasizing different historical facts. They're construing the history differently, and then they're reaching different results in the same case. So with respect to altered serial numbers, for instance, one of the things the Supreme Court said is that modern courts have to compare modern and historical laws in light of how and why modern laws impact armed self-defense. Well, it's unclear how a law that simply restricts somebody from removing a serial number has any impact on that person's ability to engage in armed self-defense. So there are differences of opinions there, and the opinions are coming out and pointing in different ways, different directions about what the Second Amendment means.
Let me just ask Mr. Lindley, all your work in law enforcement, how does it affect you? There's discussion about law-abiding people aren't the problem. We all agree with that. Makes sense. But you deal with a lot of other people who aren't so law-abiding, and also law-abiding people who have a temper and have a gun and have a domestic partner, sometimes in that moment are not so law-abiding. Can you comment?
So we've talked a lot about individuals and all the arrests that they've had. One of the things that we have here in the United States is you are innocent until proven guilty. You can have a lot of arrests, but individuals with mental health problems, convicted felons, people with a history of other types of violence, whether it's a misdemeanor, those individuals with firearms it's a poisonous cocktail, not only to the community, but to law enforcement, and they're very difficult and dangerous to deal with.
Thank you. Yeah, my time is up. Thank you. I yield back, Mr. Chairman.
Thank you, Senator Welch. Senator Lee.
Thank you, Mr. Chairman. I do think it's important in this conversation to remember that we're not talking about legislative priorities from 200 years ago. We're talking about a provision of the Constitution. It's different than a legislative priority. When we adopt something into the Constitution, we're making a law that's meant to stand the test of time. Unless or until that amendment is removed or altered, it stands. And it's the job of the court to interpret what that means. And that's exactly what happened here. I do think it is important, and I agree with Senator Welch, that it's very important that we always focus on the rights of the law-abiding and keep those in mind whenever we consider legislation or legislative strategies here. One of the worst things you can do, particularly where a constitutional right is involved, but really in any case where you're dealing with something that involves public safety, is what are we doing that might make it more difficult for the law-abiding to defend and protect themselves? What is this legislation going to do to make us safer or less safe? It's important to remember a few dynamics that are well known with respect to this study of criminal offenses and with respect to advice that we've received from seasoned law enforcement officers. Just last week, DC Police Chief Robert Conti remarked that, quote, "If we really want to see homicides go down, keep bad guys with guns in jail." He went on to say, right now, the average homicide suspect has been arrested 11 times prior to them committing a homicide. That's a problem. Mr. Mungwalt, do you want to respond to that? Is this, do you share this view that if we want to keep homicides down, we ought to arrest, convict, and detain those who are violent?
I do share that view, especially with respect to the last part of that, plan, the detainment part. I mean, the failure to incapacitate repeat offenders is at the core of America's gun violence problem and has been for a long time. If you look at the statistics on people who are charged with homicides or shootings, you will inevitably see long criminal histories that involve multiple arrests, multiple convictions, and often active criminal justice statuses. Until that changes, we are going to continue to deal with this problem, especially given the fact that over the last 10 years, we have exacerbated it by enacting all kinds of reform efforts that have, again, lowered the transaction cost of criminal offending in important ways, whether we're talking about bail reforms, discovery reforms, sentencing reforms, decriminalization efforts, the electoral success of the progressive prosecutor movement. All of these things have come together to make it less likely that when individuals come before a court of law after being charged with a gun crime or some other kind of serious offense, it becomes less likely that they will be prosecuted and incarcerated. And if they're prosecuted and incarcerated, less likely that they'll be there for a significant period of time.
And as a case in point, just recently, the District of Columbia Council voted to reduce criminal penalties for a lot of these same offenses. They're the same bad guys committing violent crimes with guns. And so it defies reason and logic to say that that is not a problem when we know that is the source of the problem. It's also important for us to remember how the Bruen decision reached its conclusion and the constitutional reasoning on which it was based. I find especially helpful the penultimate paragraph in the majority opinion, which reads as follows, quote, "The constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. And is not how the First Amendment works when it comes to unpopular speech or the free exercise clause or protections with regard to the free exercise of religion. It's not how the Sixth Amendment works when it comes to a defendant's right to confront the witnesses against him. And it's not how the Second Amendment works when it comes to public carry for self-defense." Ms. Swearer, do you agree with that assessment, both as a matter of constitutional reasoning and as a matter of logic when dealing with crime?
Senator, I absolutely do. The Second Amendment, especially in what we saw with New York's framework, was fundamentally treated and held to a different standard. You essentially had millions of residents who were told, regardless of what the text says, you might have a right to keep, but you don't have a right to bear arms the second you leave your home, which renders toothless that unalienable natural right to self-defense on which the Second Amendment is based. And so certainly for those residents in New York and the 7 other states with those types of public carry frameworks, their rights were being treated and held to a second-class standard.
I see my time has expired. As I wrap this up, I just want to emphasize again, like the Second Amendment isn't something new. Yes, it is old. It's been in place since 1791. That's a long time ago. It doesn't make it irrelevant to our time. In fact, as we've seen crime increase, I don't think it's ever been more relevant, particularly when you look at those who are victimized, those who are at a competitive disadvantage with regard to size, strength, speed, wealth, assets, where they live in proximity to a police station, and the availability of police officers who could come either sooner or later to their home. This is, moreover, something that it had its roots centuries before the American Revolution. These were well understood terms. This is not an exaggeration. This is not a modern day rewriting of a piece of the Constitution. This is a correct application and one that is right. Thank you, Mr. Chairman.
Thank you, Senator Lee. Next up is Senator Klobuchar.
Thank you very much, Mr. Chairman, and thank you. I had other hearings and things going on, but I caught up on your testimony, and I just want to thank you all for being here in this important hearing and thank the chair for calling it. One of my focuses on guns has been on domestic violence. For too long, domestic abuse was considered a family affair. And they would say what happened in a house didn't have to come into the courthouse. We all know times have changed with the passage of the domestic violence bill, the reauthorization of it many times. But we also know that when a gun is present in the home, women in abusive situations are 5 times more likely to be killed, which is why, as part of the gun safety bill on a bipartisan basis, we put in a version of the bill that I have been working on with Senator Hirono and others for years to make sure that people that are convicted of domestic abuse can't go out and buy a gun the next day. As a survivor yourself, Ms. Glenn, can you first say more about the dangerous connection between domestic violence and gun violence? And then you could add on to that just your concern about the Bruin decision and what that will mean. Go ahead.
Thank you so much for the question. The concern, of course, is that what I stated earlier, which is that victims will feel less safe because there's the idea that at minimum, when and if I felt like I could do something about it, now I can't. I cannot get the gun removed. Secondly, I would say that we are also talking about abusive persons feeling a bit more freedom to take that few seconds to pull the trigger on a gun when there's domestic violence present by them. What we're seeing is widespread confusion, widespread concern about this particular ruling and what it will mean to the future. As we all know, domestic violence victims very seldom, if at all, call law enforcement simply because of the already present danger, particularly when there is a firearm in the home. The concern is really quite marked right now, what this will mean outside of that Fifth Circuit.
Okay, and I know Mr. Lindley, you mentioned this in your testimony. Do you want to add anything?
Thank you for the question. With domestic violence and firearms, it's a lethal cocktail. You already stated the statistics that women are 5 times more likely to be killed when there's a firearm in the home with domestic violence. With that, there's also a danger towards law enforcement and just the greater community. So we need to really look at protecting those domestic violence restraining orders in order to ensure that women or other victims are protected and we remove those firearms from an already volatile situation.
Okay, and I know you also are expert on this. So my state has passed a number of common sense gun safety laws to prevent convicted felons, fugitives from justice, and convicted stalkers and domestic abusers from getting a gun. And we also have this very strong tradition of hunting. It is a big part of our life with legal gun owners and people who are law abiding, but yet we've been able to differentiate those that shouldn't have a gun, who have broken the law, and those that have not. And so could you talk about how the Bruin decision complicates efforts by state and local governments to protect public safety?
Thank you. So California has a program called the Armed Prohibited Person System, which identifies individuals who at one time legally purchased a firearm, but subsequent to that purchase became prohibited due to a mental health issue, due to the restraining order, or some type of act of violence. That has been a very successful program, identifying people who no longer have the ability to possess firearms because of an act that they've done or a mental health issue. It doesn't deal with individuals who are still law abiding. So with those things combined, you look at Bruin, and again, I'm not an attorney, I'm looking at this from a law enforcement perspective, that could muddy the waters with who might be having their restraining orders removed because of some act going back to 1791. Things are far different in 1791
Okay.
than they are today.
Okay, my very last question, Professor Rubin, in your dissent in the Bruin case, in his dissent, you didn't have a dissent, you probably were thinking one. In the dissent in the Bruin case, which was Justice Breyer was joined by Justices Kagan and Sotomayor, he asked this question. He asked, will the court's approach permit judges to reach the outcomes they prefer and then cloak those outcomes in the language of history? Based on the cases that have recently applied Bruin, how would you answer Justice Breyer's question?
History does not speak with one voice when it comes to the tradition of firearms regulation. And one of the big risks of Bruin that we are seeing right now in the way that lower courts are addressing constitutional questions after that opinion came down last June is that courts are picking and choosing different historical laws to emphasize. They're construing them differently. They're reading history at different levels of generality, and they're pointing in opposite directions about what the Constitution means. So without more clarification about how exactly to do the Bruin test, there is a real risk that opinions will, cloaked in history, will actually be subjective.
All right, well, I will ask the rest of my follow-up questions on many on the boyfriend loophole bills and laws, implications of these cases on that, but I will do that on the record because I know my colleagues are here ready to ask. So thank you.
Thanks, Senator Klobuchar. Senator Blackburn.
Thank you, Mr. Chairman. We appreciate so much that you all are here. It's an important conversation to have, and we are grateful for your testimony. You know, the chairman said he just couldn't square why some people would purchase guns or have guns. What I can't square is why we have prosecutors and judges who are letting criminals back out on the streets and not holding people who have committed crimes. And that's letting people that shouldn't have a gun get a gun. So let me ask, Mr. Lindley, let me start with you. Do you know who Jack Wilson is?
Actually, I do not.
Okay, you don't. Elijah Dickin?
I'm not really a name person, so no.
Okay. Well, let me tell you, these are both Good Samaritans that exercised their right to carry a firearm, and as a result, were able to intervene during a mass shooting, one in Texas, one in Indiana, and they saved untold lives. These are the law-abiding citizens that we want to be carrying guns and whose right to do so is protected by the Second Amendment. What about Tyree Reynolds? You know that name? Christian Wingfield, do you know that name?
They're familiar to me, but not in detail.
Not in detail. Well, they should be. These are criminals who committed violent crimes using firearms, and then they were released back to their communities as a result of the radical left's soft on crime policies and the Soros-backed bail reform. So they got out. They went on to participate in shootings. One of these individuals left a child dead. So this is the disparity. It is outrageous, absolutely outrageous. Instead of prosecuting violent criminals who are committing these crimes, that many on the left are focused on criminalizing gun ownership for law-abiding citizens. Violent crime is raging across this country. We hear about it in communities. Every year I visit with each of our 95 counties in the state of Tennessee. I visit with law enforcement in those counties. And what we hear is with gangs proliferating, with drugs flooding this country because of the cartels, because of that open border, crime is on the rise. And there seems to be a penchant, though, from my colleagues across the aisle to restrict self-defense options. Senator Graham talked about this at the outset. This is a right. The Second Amendment is a right. Senator Lee just mentioned it's the only right, that you've got to go talk to a local official and get a license in order to exercise that right. But we have plenty of people that are alive today because Jack Wilson and Elijah Dickin chose to exercise that right. And in exercising that right, they saved a lot of lives during a time with a mass shooting event. And we ought not to have people that try to restrict self-defense options for Good Samaritans. They should be spending their time trying to get violent criminals off the street. Ms. Ware, I'd like to come to you for a moment. I led an amicus brief last month to support the lawsuit challenging ATF pistol brace rule. This imposes potential criminal liability on millions of Americans for exercising their Second Amendment rights. The ATF claims that this rule is necessary because arm braces transform a pistol into a short barrel rifle. Now, when I'm back at home in Tennessee and I'm talking with a lot of our veterans and our disabled combat veterans, they talk to me about why they rely on these pistol braces to be able to operate a firearm, to operate that gun. So can you explain how our disabled combat veterans use pistol braces and the devastating impact that the ATF rule would have on their ability to exercise their Second Amendment rights?
Senator, thank you for that question. Pistol braces work in such a way, so if you understand a handgun, which generally speaking, you can hold with one hand. A lot of these disabled veterans cannot use that second hand, for example, as a additional stabilizer, right? So they have trouble using that with one hand. The way that the pistol brace works is that it extends a lot of them down the arm and either allow the person with that brace to brace it against their inner arm or to even strap it into their forearm to give them additional stability.
So it's a safety mechanism.
Correct, yes.
It stabilizes the handgun.
Correct. And to the extent that someone is not disabled, they would have a plethora of other options. Again, whether this is a criminal, for example, they don't need to rely on a stable brace. They can just use a handgun or, for example, use a rifle. This exclusively is something that is beneficial to law-abiding but disabled citizens. And it might be used by people who are not disabled, but that is primarily a benefit to them, while at the same time, again, would-be criminals have a plethora of alternatives to accomplish their criminal goals.
Thank you, Mr. Chairman.
Thank you, Senator Blackburn. I want to thank Chair Durbin and Ranking Member Graham for holding this hearing. There's no denying that we have a gun violence epidemic in the United States of America. When gun violence becomes the leading cause of death in America, or yet another small town becomes a household name because across the country because of another tragedy, we have a moral obligation to act. Just yesterday, I joined President Biden in Monterey Park, California, to meet with the community that's still grieving from a mass shooting that took the lives of 11 people at a dance studio on the eve of Lunar New Year. I was pleased to see President Biden announce his executive actions that will make our community safer and will save lives. But I think we all acknowledge, including the president, that these executive actions to address gun violence do not absolve us of our duty as legislators. Now, last Congress, this committee held 11 hearings on common sense steps to reduce gun violence. And we know that the overwhelming public support these measures have. But as we gather here today, just after America surpassed 100 mass shootings in this calendar year, that's 100 tragedies by the first week of March. And Americans are watching from home, asking, when will Congress step up and do something? So I'm committed to finding a path forward and look forward to working with whoever is willing on the other side of the aisle to end the epidemic of gun violence in our country. Now, my first question is for Mr. Lindley. As a program manager for Brady's Combating Crime Guns Initiative and as a former law enforcement officer, you spent a good part of your career combating gun violence. The Brady Handgun Violence Prevention Act created a system requiring background checks for gun purchases from licensed dealers. And yesterday, President Biden announced a new executive order directing the Attorney General to ensure that gun dealers are following existing laws concerning background checks, highlighting the role gun dealers have in limiting the proliferation of guns in our communities. Are you concerned that the Bruin decision will lead to looser gun laws, and in particular surrounding the registration of firearms, and then undermine our efforts to improve safety?
Thank you for the question, Senator. Absolutely. Again, I'm not an attorney, so I can't see the future when it comes to legal issues.
That's okay. I'm not one either.
But if you look at some of the things that have been put into place, especially with the Brady background check process, it didn't go far enough back in the 90s. So we do have to look at universal background checks, something that California has put into place and has been very successful with. You also look at limiting, if not, outline new purchases of assault weapons and high capacity magazines. Again, something that California has put in and has been successful over the years.
Thank you. And I don't mean to make light of the fact that you're not an attorney, nor am I. Trust me, we hear from a lot of attorneys in this committee. There's a lot of attorneys on the committee. But I do want to uplift your perspective with your law enforcement experience to this conversation. Now, as a former law enforcement officer, you've experienced the epidemic of gun violence firsthand. And I think you'd agree that the Monterey Park shooting was simply a high-profile example of the epidemic that we have in this country. I mean, in a span of 8 days surrounding that one incident, California experienced at least 2 more. In your opinion, what role does the availability of large capacity ammunition magazines and semi-automatic assault weapons play in the gun violence plaguing our nation?
Again, after almost 30 years in law enforcement, seen far too many victims, far too many mass shootings. And when you look at the lethality of semi-automatic weapons, especially assault weapons, coupled with the high capacity magazines, it makes it very difficult for the victimology. If you look at how many people can be shot in that time frame with a 30-round magazine as compared to a 10-round magazine. And we've seen instances here in California that an individual who went in, did a mass shooting, but had a lower capacity magazine, had far fewer victims. But individuals usually have to wait until the person reloads until they engage and try and disarm the individual. A lot of different victims can take place between 10 rounds and 30 rounds, or let's say in Las Vegas, 50 or 100 rounds.
Thank you very much. Love to have some follow-up questions here, but at this point, I'll turn it over to Senator Blumenthal for his questions.
Thanks very much, Senator Padilla. Thank you all for being here. Thank you to the advocates who have joined us today. And I want to thank Senator Padilla and other members of the committee for their steadfast support of measures that will stop that epidemic of gun violence. These measures are made vastly more difficult by the Supreme Court's decision in Bruin in ways that we have no way of knowing at this point, because Bruin remains an inchoate and deeply frightening potential obstacle to common sense measures. I could talk about a great many of them, but I want to focus on safe storage laws, known in Connecticut as Ethan's Law. Our law is named after a young man who was killed when he was accidentally shot by an unsecured firearm. Ethan Song was a teenager at the time, and the firearm had been stored in a Tupperware box in a closet alongside the ammunition and keys to the gun lock. Ethan's Law passed in Connecticut, but we know across the country 4.6 million minors live in households with at least one loaded and unlocked gun. An estimated 54% of gun owners don't lock all of their guns securely. Ethan's Law simply requires that guns be safely stored. Doesn't take away a single gun, doesn't look at who owns the gun, doesn't provide any ban on any type of gun. It simply says if you have a gun, you should save storage, safely store that gun. So I would like to ask Professor Rubin, based on the Bruin decision, whether that kind of law would be constitutional under the court's apparent reasoning that there has to be some historical analog on which any kind of law is based under the Second Amendment.
Thank you, Senator. So as you mentioned, there's a lot of uncertainty right now about what Bruin means and how it will apply to specific gun laws, including that one. Before Bruin, safe storage laws fared very well in the courts. And after Bruin, the question will be, first, whether or not the storage of a law or laws about storage fall within the plain text of the Second Amendment. That's an open question. And then the second question that will be asked is whether or not they have historical analogs. And it's a challenging one. This is it's a good example of the challenges that courts have now. Because back in the framing era, the guns were largely muzzle-loaded black powder guns that were not kept loaded or carried loaded because of the risk of misfire. There were laws about storage back then. For instance, there were laws in the city of Boston and other places about storing gunpowder separate from the firearms, but those were because there was a risk of fires. It was a different time with different problems, and the policymakers back then addressed the problems that existed. Today, the problems, as you mentioned, are different than the problems back then, and a lot will depend on how flexibly courts look to historical laws like the Boston safe storage law, and how they relate them to today. And it's very much an open question. But one thing is for sure that the court did say that a lot of regulation is still permissible under the Bruin standard.
I think your point is very important, that an analog means exactly that it doesn't have to be exactly the same. And the laws, for example, that you cited in Boston requiring safe storage of some of the materials used in firearms or firing weapons, perhaps provide that kind of analog. And today the risk may be different. In fact, gun deaths have recently surpassed any other kinds of deaths affecting children. Gun violence is the most common cause of child death in the United States today. An estimated 8 children and teens are killed unintentionally, injured, or killed due to an unsafely stored firearm. So the risk may be different, but the analog is the same insofar as it says risk can be taken into account in requiring safe storage.
And that's absolutely correct in terms of how courts are going to have to apply Bruin in light of changed circumstances. And one of the problems that I've seen in opinions that have come out after the Bruin decision is that courts in effect are looking for dead ringers. A lot of courts are sidestepping the analogical exercise altogether and just looking for dead ringers. Well, that's not how analogical reasoning works. And in fact, historical laws are going to have to be viewed at a relatively high level of generality, flexibly, in order to accommodate the reality of change over time.
Well, thank you very much. Thanks, Mr. Chairman, for having this hearing. I'm going to continue to advocate Ethan's Law at the federal level and other measures that I've introduced here, trying to encourage the courts to interpret Bruin expansively, because it really is a matter of life and death. And I commend President Biden for taking the action he did yesterday. Thanks.
Thanks, Senator Blumenthal. I want to apologize personally and for the committee. Our coming and going have a lot to do with things beyond our control. One of them is roll call vote on the floor. So members have to make the roll call and try to make this committee hearing and others at the same time. It is not a display of disrespect. It is the reality of our frantic lives here when we're in session. But your testimony has been very important and very valuable. Professor Rubin, I was just trying to think, if we use the same standard of Bruin, of historical analog, we have a hearing coming up on social media and the internet. And I'm trying to imagine how we would do such a thing in light of the First Amendment, speech and press, and what we would be guided by. What really was the state of social media in 1791 or in 1868? I think it's ridiculous on its face. And you wonder why the court, particularly Justice Thomas, who has his own peculiar view of the Constitution, wonder why the court is buying it in this instance. Do you know what the end goal was, the real reason? Not the good reason, historical analog, but the real reason?
I don't know about the intentions of justices. Obviously, one thing that happened before Bruin was that the courts were applying doctrine pulled from First Amendment cases. Heller cited First Amendment jurisprudence repeatedly. In the First Amendment context, we do not solely decide cases on the basis of history alone. Rather, history is one input, but so are contemporary costs and benefits. So to your point about social media or other First Amendment issues, Supreme Court has said, for instance, that child pornography is not protected expression under the First Amendment. And in arriving at that decision, they were not looking for analogs in the founding generation. This is a unique test that has been put forward for the Second Amendment.
Senator Lee talked about the constitutional language standing the test of time. We might engage in an exchange as to whether or not the original language of the Constitution stood the test of time on the issue of women voting, on the issue of slavery, on the issue of property landowning males being primarily the voting populace at the time. There are a number of things in the Constitution which were flawed, some corrected by constitutional amendment and some by court ruling. Is that not the case?
That's true. And the Supreme Court in Bruin said that the Second Amendment is to withstand the test of time and change over time. And the question right now is how to do the Bruin analogical exercise in a way that will respect the reality of the fact that things were very different back in the 1790s than they are today. A lot of the problems that we have with respect to firearms and weapons today would have been unimaginable at the founding. So of course they weren't legislating on those issues. And yet our task, the task of courts and litigants today is to draw analogies between that time and now.
And I wonder how our founding fathers would have reflected on a chilling milestone as we surpassed 100 mass shootings a little over a week ago. That's more than one a day. We ended last year with 647 mass shootings, which means four people were shot or killed in an incident. 647 last year, almost 2 a day, and more than 44,000 people overall killed by gunfire. It appears the proliferation of weapons in America has not brought peace to our streets, but just the opposite. And that's what I've witnessed many times over. So I thank you all for being here today, and I thank you for your testimony. The hearing record will remain open for a week for statements and questions. I thank you for participating, and the hearing stands adjourned.
So thank you for the question. And I have not shared this probably in a few years on this floor, but I will at this point. So I appreciate the opportunity to do so. There are many of us in this room who have been touched by violent crime and whose families, the trajectory of your family has been altered. When I was just a child, my Aunt Lola was killed by a drunk driver. She was a wonderful young lady. She was 15 years old, and a drunk driver hit and killed her before I ever even got to know her. I know her through photographs. There are thousands and thousands of families throughout this state who know their relatives through photographs and stories. And for generations, their families are torn apart. I also know from what my parents went through, what the entire family went through at that time, and the 7 years I spent as an assistant district attorney, and then the many years since in private practice, just how devastating it is for victims of crime, especially violent crime, to go through the criminal justice system. Yes, absolutely. I join you in saying we should do everything we can to rehabilitate those that are incarcerated. But when you have to go through the parole system over and over and over again, it is devastating for both the defendants' families, and I guarantee you the victims' families as well. Every time that a person is up for parole, it reopens those wounds that have barely begun to heal. So we all come to this chamber from a place of personal experience and representing our communities. Mine has always been that while we focus on justice for the defendant, while we focus on a system that should rehabilitate those individuals, I have always stayed laser focused on the innocent victims of violent crime to ensure that our communities are safe and that we do everything we can to both reduce the number of victims and survivors we have out there so fewer families have to go through what my family went through, but also to make sure that at every turn we can make that criminal justice process a little bit easier on those victims. They didn't make any choice to come into the criminal justice system. They were dragged into that criminal justice system because of the actions of another. So with this bill, the reason that this vehicular homicide, where someone kills someone in a vehicle and leaves the scene, very callous behavior, obviously, if they are tried, if they are convicted, if a judge decides to give them a 2-serve sentence, then no victim's family should ever have to go back to the parole board over and over and over again to beg this system to keep that individual incarcerated. That's the reason for the bill.
Representative Pearson.
We're going to disagree vehemently on this because there's no proof that this works, that telling someone that they serve 100% of their sentence works. And in fact, it's a false solution because victims are not being prioritized in the process. For instance, if you look at restorative justice, what's required is both a victim and the perpetuator of the harm to reach a solution. This doesn't offer an opportunity for a victim's family to say, I would like to meet them, speak with them, see them, talk with them, right? It doesn't do that. It says that this legislative body can think for those victims. And I am sorry about the losses that you have experienced. And I too have experienced loss. My own cousin, TJ, was killed because of gun violence. And you see how hard I'm working, and we're working up here to change that. But the reality is this is not a fix. This is not a real solution to preventing crime, nor for helping citizens who are incarcerated, who have committed atrocities or bad things, from being rehabilitated. And we shouldn't be dictating that if you serve 100% of your time, we have somehow fixed or solved the problem. That just is not true. And it only feeds into further mass incarceration, which we have in this state and should stop.
Lear Lambert.
Thank you, and thank you for your comments. I will tell you that the recidivism rate on those that are incarcerated is virtually zero. While they are incarcerated, they will not harm any other Tennessean outside those prison walls. I want them to get help, but they cannot hurt anybody while they were there. And I believe in restorative justice. I do. I believe that those survivors that wish to reach out and have some contact with the defendants that harm their family, I support those efforts, but I will tell you, I don't want to meet the man that killed my Aunt Lola. What I want was for her to be able to grow up and graduate high school. I want to make sure that she was able to get married and have children, to be able to experience my life. I would hope that my Aunt Lola would be able to be here in the balcony today. But a man who thought it was more important to get drunk on his way to Mardi Gras with his buddies stole that from me and my family. So forgive me if I fight for those folks instead of the deadbeat that killed her.
Representative Warner, you're recognized.
Thank you, Mr. Speaker. I move the previous question.
Previous question been called. Any objection? There's objection. We're voting on previous question. All those in favor say vote aye when the bell rings. Those opposed vote no. Mr. Clerk, take the vote.
Aye, 72, 23 nays, one present, not voted.
House Bill 1444, having received the Constitution majority, I hereby declare passed. Oh, previous question, my fault. Previous question failed. We are voting. All those in favor of House Bill 1444 as amended, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, take the vote.
Ayes 80, 16 nays.
House Bill 1444, having received the Constitution majority, I hereby declare passed without objection. Most for considered table. Call up next bill, Mr. Clerk.
House Bill 403 by Leader Lambert and others relative to cannabis. Mr. Speaker, Senate bills on the desk.
Leader Lambert, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 378.
Leader Lambert moves substitute and conform Senate Bill 378, probably second without objection. So ordered. Leader Lambert.
Thank you, Mr. Speaker. Move passage of Senate Bill 378 on third and final consideration.
Leader Lambert moves passage of Senate Bill 378 on third and final consideration, probably second. Mr. Clerk, call it First Amendment.
House Criminal Justice Committee Amendment number 1.
Chairman Halsey, you're recognized.
Thank you, Mr. Speaker. House Financial Ways and Means Committee Amendment 1 improves upon this amendment. And with that explanation, I move to withdraw House Criminal Justice Amendment 1.
Without objection, amendment number 1 withdrawn. Next amendment, Mr. Clerk.
House Finance Ways and Means Committee Amendment number 1 filed as House Amendment 2. Mr. Speaker, it's the same as Senate Amendment 3.
Chair Lady Hazelwood, you're recognized.
Thank you, Mr. Speaker. Since it's same as the Senate amendment, move to withdraw.
Without objection, amendment number 2 withdrawn. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Leader Lambert, you're recognized.
Thank you, Mr. Speaker. And members, we worked on this a lot last year to try to deal with the issue of hemp-derived cannabinoid products. There are no regulations on those products currently. Any child can walk into a store, buy as much of this product as they would like, and many of those children have overdosed. Not a lethal overdose, but still a definitely medically dangerous overdose that they should not be exposed to these products. So this bill does many things, but in large part, it puts some very strict regulations around these products, ensures that they can only be sold to those that are over 21. It puts packaging and testing and taxes and everything else on these products because they are out there. They're all over the state, and you can't walk into a convenience store, a grocery store, a market somewhere without seeing them. And most of our constituents have no idea what they're buying. And it's because there's no regulations. And so this really does ensure that, these are behind the counter, they're for over 21. It goes after any bad actors that would try to prey upon innocent
are submitting as of today without oral argument. And those cases are 21-13-48 Singh versus Garland, 22-15-290 JB versus Craigslist, 22-894 Sun versus Garland. And that's it. So if those three cases we're submitting, those cases will be submitted as of today. We have three cases for argument. I believe that they all are, they're all 15 minutes per side. They all, I think, two of the cases have cross appeals. And so I believe that including the first one, I believe that you should have been told already that for the cross appeals, the cross appellant will have the option of going last, but you'll get 15 minutes total time. So maybe let us know when you get up for your rebuttal to the opening appeal, how much time you plan to reserve. And then, we will try to accommodate that. I guess one thing I should announce is that 15 minutes is your total time. So if you eat into your, some people I think have misunderstood that. If you eat into your rebuttal time, you don't necessarily get to have the amount of time you're hoping to keep. With that, we'll start with the John Doe versus Twitter case. And go ahead and announce your name and how much time you plan to keep for rebuttal.
Good morning, Judge Van Dyke. May it please the court. I'm Derek Schaefer here on behalf of appellant cross appellee Twitter. With the court's permission, we would ask to reserve 5 minutes of time for rebuttal, please. With that, Your Honors, I will proceed. In our respectful view, the Reddit decision of this court disposes of this appeal and necessitates reversal because it is now established as the law of this court. Section 230 protects Twitter's unless its alleged conduct was criminal under Section 1591, which it isn't, and the district court didn't find it could be. And you can see the most telling portion of the opinion at ER 34. The conduct, Your Honors, must be that of the defendant here, Twitter, that is analyzed by the court and deemed to offend the relevant provisions. The defendant must be complicit in actively trafficking a person for commercial sex acts, which I don't think any allegation of the complaint fairly alleges. And that, Your Honors, should resolve what the court below called the more difficult issue, the one presented by the cross appeal. You can see that at excerpts of record 34. Absent questions about Twitter's appeal, I'd propose then to turn to the cross appeal. There, Your Honors, I start with Section 1591, and I return to the points I previously made. I think Reddit has effectively resolved the 1591 portion of the cross appeal in holding that on the facts set forth in the Reddit complaint, there could not be a violation. The same holds here, just as it holds in the Craigslist case. You can find the key portion of Reddit at 51 F 4th, 1145 and 46. There's no trafficking of a person, Your Honors, which was rightly the focus of the district court at excerpt of record 34. There's no overt act reflecting affirmative participation by Twitter in a venture. That would be a sex trafficking venture. And Your Honors, there's no future causation. The language of the statute is very clear. And again, it's a criminal statute. It needs to be conduct that will cause a victim to engage in a commercial sex act. The allegations here allege the opposite, that any alleged trafficking venture had been completed in 2017 or thereabouts before a different third party uploaded the offending content to Twitter.
Mr. Schiffer, let me pause you on that last point. I have a bit of a different reading about the will cause language. It seems to me that the criminal act is about, let's start with the direct liability theory, enticing or doing other acts with that person having knowledge that the victim is a minor and that the enticement will cause a future commercial sex act. I don't have the impression that it requires someone to prove that a defendant is likely to commit sex trafficking in the future, but it's tethered to the knowledge requirement itself of when someone was enticing, it was with the purpose of a prospective commercial sex act.
Judge Sanchez, I'm not sure that disagree with your account in a theoretical sense. That is to say, if there is some other actor who will be the cause of a victim engaging in a future commercial sex act, I think that could suffice. But I think the language of the statute is very clear, and it is, again, a criminal statute. And I know Your Honor's read it, but it says specifically, you benefit financially or by receiving anything of value from participation which has engaged in an act described in paragraph 1, knowing that the advertising reckless disregard of the fact that means of force, threats of force, fraud, coercion described in subsection E2 or any combination of such means will be used to cause the person to engage in a commercial sex act. And I think on these facts, where any alleged solicitation by someone else was effectively completed, and the theory of the complaint is they were distanced, the plaintiffs here were distanced from the initial offenders, there's just no way to say that Twitter knew that anything being uploaded to its platform will cause that act. And the only way that I think my friends for the other side get around that is trying to say that the mere depiction, the image that depicts something in the past, is sufficient to offend 1591. And I just don't think that can be so, any more than if we're talking about a person who had a photo taken of them without their consent. That's not kidnapping of the person.
But if the images constitute criminality under 1591 and the platform has an algorithm that allows those images to be disclosed, certainly someone within the company should be scrutinizing whether or not the company's advertising, promoting, disclosing images that are criminal in nature. And if even tacitly the company doesn't do anything, doesn't that then constitute at least some form of knowledge that would trigger the criminal statute?
So, Judge Murphy, I'll talk about 2252 and 2255A. I think Your Honor's question sounds more in terms of that, because we're talking about depiction, divorce from any sort of physical sex acts. And I would note, Your Honor, it is a shared premise that Twitter, wants to be scrutinizing the content on its platform. 500 million tweets a day, according to paragraph 23 of the complaint. And they're doing that, Judge Murphy. That's set forth in the complaint. That's exactly how the plaintiff faults Twitter for not having been allegedly true to that policy in this specific instance for a period of days. And we want to be better. We're striving for perfection. So we want to be doing that. The question is, are we violating the criminal statute to the extent that we allegedly miss one for some period of time? And my answer is no. No. And I think that is what Reddit holds. I think that is what the district court held in the Craigslist case. I think it's what the district court was holding here, except for its misconception that 1595 would suffice to establish civil liability under falsehood. And that's what this court has corrected in Reddit.
Let me direct you to what I think is the nub of the case, and that is the contention that Twitter was made aware of this type of material on its platform and refused to take it down. And I think that's arguably a distinguishing factor from the allegations in Reddit. Suppose plaintiffs made an allegation that refusal in keeping the platform up helped or financially benefited or did something to help sex trafficking of children whose videos are raised onto Twitter's platform. Would that be sufficient to allege a 1591 violation?
Let me just start with the Reddit case itself, because there were those allegations, Judge Sanchez, and the court acknowledged that. In Reddit, the allegations were that Reddit knew of specific child pornography depicting the plaintiffs there and had failed to take it down. So in that sense, it's on all fours. To take your question, Judge Sanchez, you have what my friends for the other side cite in terms of the Mind Geeks case. You have what they cite, also the Georgia case, the Free Sites case. Those are cases where a different website, Pornhub and sites associated with that, were essentially engaged in the sex trafficking venture, allegedly. They had a profit-sharing arrangement with the direct traffickers. They were promoting that content specially. They were advertising the plaintiffs in that case. They were changing the images and taking essentially thumbnails of those to depict on the website. When those things are happening, Judge Sanchez, they are, according to the district courts in that case, affirmatively engaged in sex trafficking within the meaning of 1591. But that categorically differs from what you have here. A theory of the case that says passively, other third parties, not the direct traffickers, uploaded content that was not detected and brought down quickly enough. That is exactly the case in which Reddit says we have the protections of Section 230, unless and until Congress may revise those protections. That's the choice that Congress
So
has
that,
clearly
in
made.
your view, that's too passive to constitute active participation, even if some plaintiffs somehow allege that the inaction of not taking it down somehow supports these sex trafficking ventures themselves.
Yes, Judge Sanchez, and otherwise you change the internet in a way that Congress was careful not to do in FOSTA, because otherwise an entity like Twitter, any such internet platform, has to be screening everything on the front end before it goes up.
But the argument, as I understand it, is that it's not just passive. The Twitter is actually, their algorithms are actually promoting this because people want it. Twitter's algorithms know that people want it. And so Twitter's algorithms actually actively promote this to those people.
Judge Van Dyke, I think those are generic allegations that are in the complaint. It's not that Twitter is trying to zero in on sex trafficking content or other offending content in the way that was true for the cases that I was alluding
No,
to
their
earlier.
algorithms are just designed to, in order to keep people on the screen, they're just designed to feed people something that will keep them on the screen. And that happens in child porn, keeps certain people on the screen. And so they are actually promoting child porn because those, not because I presume I don't think the allegation or somebody at Twitter said, keep child porn on the screen. It's just that those algorithms, that's the outcome of that. And Twitter knows that that's the outcome. That's what their allegations are. Isn't that right?
Well, they have allegations that are the opposite of that too, Judge Van Dyke, that Twitter has been active in taking down offending content, has been doing what it can.
This case shows, the facts aren't good for you in this case. This case, Twitter was asked to take it down and Twitter said, we've looked at it and we're not taking it down.
Judge Van Dyke, that's out of 500 million tweets and that are happening every day. And it was a period of 9 days before this was taken down.
Was Twitter not being, Twitter said they had looked at the content and determined that it wasn't child porn and we're not going to take it down. Was that just was that not actually true? Had they not actually looked at it? What's the reason for that?
Well, obviously I can't go outside the record, Judge Van Dyke, but those allegations are the allegations and we take that to heart. That means we need to be doing a better job. We're striving to do a better job in all of these respects. But on any given day and for any given content, it is a tough job to do to make sure that all of it is screened in real time, even in response to complaints. And the terrible choice that Congress was saving platforms like Twitter from under Section 230 is saying either you do everything perfectly or else you bury your heads in the sand and you do nothing. Because that is the way that a company in Twitter's position can insure against liability.
So you have a shield under 230, but that shield is removed if you under a Reddit decision, that shield is removed if you meet these heightened concepts of what participation in the venture is, et cetera. And I understand that the judge here, I think there is an inconsistency between what the judge here did below and Reddit, but why wouldn't we just send it back to the judge to do it in the first instance? You're asking us to just decide that.
Well,
right?
I think it's for the same reason that Reddit held there could be no valid claim stated against Reddit under those facts, which were, I think, materially indistinguishable from these. And the judge has also said in this case under 1591 that it leases to direct participation.
I guess we'll hear from the other side, but I don't understand. They certainly in their Rule 28J letter, and I didn't understand them in the district court to be thinking that we can only win under, I know this is before Reddit, but let's just say under a Reddit type standard. I think they were arguing that's what the standard should be, but I believe they've been arguing they could win under Reddit standard.
That's true, Judge Van Dyke, but the judge rejected their 1591 claim. The judge basically, so I want to turn, if I may, I know my time's going short. I'm mindful of the court's admonition.
I hate to prolong it, but how would we characterize it? The third party beneficiary claim. I believe what Judge Van Dyke is referencing is that the magistrate judge did not analyze that claim under Reddit. And even though I believe she said it could proceed to discovery, the legal issue that the judge raises hasn't been resolved and we should remand for that specific purpose, right?
I think I understood that to be Judge Van Dyke's
Right.
suggestion.
What's your position on that?
I think you resolve it here, Judge Murphy, because
Yeah.
Reddit said that there was no valid 1591 claim there. That's
All
what
right.
the Craigslist district court held as well. And that's what this district judge held as to the 1591 claim as a standalone, at least for the direct participation, at least for direct trafficking. And Reddit basically said, that's the same inquiry, I think.
Just want to make sure that
Thank you,
would you
Judge
want to keep
Van Dyke.
going or do you want to?
No, let me move if I made it. Well, I'll keep going because I do want to address the 2255 question for your honors and just say, I think that Reddit has resolved that on top of Barnes and Gonzalez. It's the Fifth Circuit's decision in Diaz 2, the Bates decision. They all stand for the proposition that Section 230 applies when you have this sort of a fact pattern. And when the gravamen of complaint is what we were discussing earlier, that a platform has not detected and taken down offending third-party content quickly enough. Reddit applied Section 230 while recognizing that the content at issue there was child pornography, which it acknowledged was unlawful. And it concluded that the plaintiff's claims were treating Reddit as a publisher, which is sufficient to trigger the protections of Section 230. And if that's not the case, your honors, then Reddit and FOSTA would be totally circumvented anytime you have a case like this, because a plaintiff would allege, well, we're talking about offending content, therefore Section 230 has no application. That's not what Congress so carefully did when it passed FOSTA. That's not how the court has so carefully interpreted and enforced the protections of Section 230. And if you read the complaint, I'd point you to paragraphs 99 and 128. There it's clear they bookend the plaintiff's theory of complaint, which is a third party uploaded offending content to the Twitter platform. It was left there for others to see, and then it was taken down. That's all about what Twitter is doing as a publisher, just like any of the other publishers that have been protected by Section 230 in this context. Thank you, your honors. I know I have precious little time for rebuttal, but
I don't think you have any time for rebuttal, counsel. So given that you don't have any time for rebuttal, I think we'll just have, you guys can use your whole 15 minutes and we'll be done. Thank you.
Good morning. May it please the court. My name is Lisa Haba. I'm here on behalf of John Doe's 1 and 2. To date, there has never been an appellate court in any federal circuit that has extended CDA 230 protection to incorporate child pornography. Today, Twitter wants this court to be the first to do that in the country, and I would implore this court to reject that invitation. I'm going to be discussing two matters before the court. First, we'll discuss the 1591 claims, and then I'll move on to the child pornography claims. Counsel spent a lot of time talking about Reddit and how this court has been bound by Reddit and that would apply to this case. I'd respectfully disagree for two things. First, even under the heightened Reddit standard, Twitter has met the 1591 standard in the pleadings. We have
Counsel, let me just make sure, because I understand from having read both sides' Rule 20J letters. Your view is Twitter doesn't affect your ability to win. I respect that. Their view is, just say that Reddit doesn't affect your ability to win. And their view is that Reddit kills your ability to win on the 1591 or 1595 direct. Why wouldn't we just send it? I mean, it's pretty. You would agree that the district court did not apply a Reddit type standard in ruling below, correct? On the last ruling, the ruling that's up and above.
They did not apply a 1591
right.
standard.
So why wouldn't we
correct.
just send it back for the district? And I don't get the vibe from reading the district court opinion that the district court was necessarily. I disagree with Twitter that the district court that has decided the question of whether you could win on your indirect claim. So why wouldn't we just send it back for the district court to decide that in the first instance to address that, applying Reddit, because we're bound by Reddit.
Of course, this court is bound by Reddit, and I respectfully, of course, this court could do that. You do also have de novo review over this matter, and we also have a cross appeal on a child pornography matter, which was not addressed by Reddit. So I think this court could certainly look at the issues today and make a determination on its face.
I'm just
where we
trying to
stand.
narrow down. We only have 15 minutes. I'm trying to narrow down, like, should we be talking about how much time we want to spend talking about that indirect claim, because we don't have the benefit of a district court decision that applied that standard. So why wouldn't we just send that back and we can talk about your other claims?
We don't have anything to review de novo. There's no decision on the third-party beneficiary claim under Reddit.
There's a decision, but it's applying the wrong standard, as you know, under our circuit precedent now.
I understand the court's view. I think what is interesting, though, is that we're here on a matter of first impression before this court. I think Reddit is binding upon this court, of course, as precedent before the circuit. But Reddit really analyzed a constructive knowledge standard. We are here today on an actual knowledge standard, which is different and distinguishing from Reddit, and for three main reasons. First, the knowledge required the mens rea standard. Secondly, what was the benefiting standard? And the third element of participation in a venture. To be more specific, under Reddit, they addressed whether or not the platform had constructive knowledge of the matter at hand. The Reddit opinion talks about that standard. In our case, we've pled that Twitter had actual knowledge, both of the illegal nature of the videos, the age of the children. They had actual knowledge of the filming when it came from that it came from exploitation, and there's actual knowledge they were profiting from this material. The second distinguishment from Reddit is that the court in Reddit really wasn't sure if there was a benefit.
So I was looking in Reddit here. It says, in Reddit, the opinion says that the plaintiff's allegations there were that Reddit failed to remove child pornography even when users report it. So I'm not sure that we can say that Reddit didn't involve actual knowledge. I mean, that they can distinguish Reddit that way?
Well, Your Honor, respectfully, I believe Reddit talked a lot about situations where the images would be potentially taken down and then would pop up again, or when some of the images were left up, some of the images weren't. But there was a lot of general allegations about the knowledge requirement.
Because it says, it says, the allegations suggest only that Reddit turned a blind eye. It seems that metaphor has the idea that, like, this is going on over here and you're just kind of ignoring it. And it's kind of similar to the allegations in this case.
Similar, but there's two other distinguishing factors, Your Honor, as well, in addition to the knowledge requirement. So even if this court finds that actual knowledge existed in the Reddit opinion, there still is a substantial distinguishment with the benefiting from the venture and the participation in the venture. Reddit's participation in a venture was that volunteer moderators were the ones reviewing the material. Here in our case, we've alleged that Twitter's actual employees were the ones reviewing the material. So when Twitter's actual employees took the report through the Twitter platform, they analyzed it, those actual employees verified the nature of the child pornography, they verified the fact that we had age verification with a Florida driver's license, and then that employee refused to follow the law and refused to remove the illegal images. So that is completely distinguished from Reddit, that Twitter participated in a venture, whereas the Reddit had volunteers.
Can I ask, what are the allegations that relate to direct liability? And Twitter makes much of the fact that the statute describes a person. Are there any allegations that would indicate that Twitter is substantially supporting a venture that is involving the actual trafficking of a minor?
Yes, Your Honor. There is an ongoing criminal violation here. So in many sextortion schemes where we're looking at sextortion as a way to engage in sex trafficking, we have part one, if you will, where the minor was trafficked through the Snapchat application, and that was where the videos were created. Those videos, there was a lot of threats made back in
years ago.
It was, Your Honor. So part one of this criminal venture, which is ongoing and sprawling over years, was the creation of the videos. The threats were made that if they didn't acquiesce to the trafficker's demands, the person in John Doe 1 and 2 would have those videos released. They would be sextorted, and more videos they would use that as a bait and switch.
I think we're very familiar with the argument you're making. So the problem I have with it is, how does I would assume that much child pornography is produced in an involuntary way, and even if you were to say even that child pornography that's you put the quotes voluntary around it, wouldn't be voluntary because they're not of an age where they can actually consent. So in some sense, like all child pornography is produced involuntarily. So how does your argument? I understand your argument that this is the tail end of a sextortion. So I understand that, and I'm sympathetic to it. But the problem is, it seems to me your argument would be that essentially every posting of child pornography, if it's an entity like Twitter or an entity like Reddit or any other type of entity that allows that to happen, that they are participating in that venture because they're being used as the tail end of this extortion scheme. But it almost seems to me like I'm sympathetic to that. I think it's probably correct, but it seems like your argument proves too much. It literally makes every single posting of child pornography, any site that allows, and I mean allows by just doesn't prevent child pornography from being posted to be participating in a venture under your theory. And that, it's hard to think that that's what Congress wanted to allow with 230. But
Well, respectfully, Your Honor, I would disagree with that. I think that
which part?
the
latter
fact that
part.
just because it gets posted on a platform, it would suddenly become participation in a venture.
So
What
you,
ma-
you don't think that that's not your position, you're saying? Okay,
position,
so
Your
what's the more nuanced position I'm missing?
The more nuanced position is that when child pornography is posted on a platform, we know that Congress did not intend platforms to have to self-police the content on the platform. But what makes our case unique is they were notified through the Twitter application of a specific posting that was of John Doe 1 and 2. When they were put on notice, that's when they had a legal obligation to remove that criminal material.
Okay, but they're not, I don't understand how you, okay, if a man takes pornographic photos of his 5-year-old nephew and puts it on Twitter or wherever and says, you know, this little boy's available for sexual conduct, that's trafficking a person. But Twitter republishing photographs of 2 little boys who are not little boys anymore is trafficking images, inappropriate, no doubt, that might establish third-party beneficiary liability, no doubt, but certainly can't constitute direct trafficking of a person as set forth in 1591A1, right?
Well, Your Honor, in 2000, when the TVPA was first codified.
But just answer my question.
So no, Your Honor, I
No,
disagree.
Of course not. You disagree with that?
That was not the intent of Congress. Congress equates.
Wait, you think that Twitter was trafficking these 2 boys, John Doe 1 and 2, for sexual conduct?
I believe that's not the definition of what
It is. It says
TVPA.
it in the statute. 1591 bans the trafficking of a person.
Yes, and Twitter was directly trafficking John Doe 1 and 2, and Twitter was benefiting from the trafficking of John Doe 1 and 2.
Question that's kind of a follow-up to that. It's just, I mean, the argument absurdum, right? Like, to take it to its logical conclusion. 100 years from now, we're all dead, right? And these pictures are still going up. I think under your theory, they would still be trafficking them. They'd be trafficking people that literally aren't alive.
Well, Your Honor, with all due respect, pornography is a part of sex trafficking if it's done of children and it's done with knowledge to violate 1591. So our position is that when these images were created and Twitter was put on knowledge, they had a choice to make. They were put on knowledge that it was criminal conduct. They were put on knowledge that it was a sexual act. It was a commercial sexual act, and it was done of a child. Right. That is the definition of 1591.
Right.
We've alleged that they obtained it. We've alleged.
So your whole theory, just to be clear, is that because once they're told, because we have all this other, this kind of argument gets made in other contexts, and I understand your argument is child pornography is different because there's nothing legal about it, right? It's
right.
Complete, I understand that, but you do recognize we have a lot of cases that basically don't let it turn on the fact that you've been told as an internet service provider or as one of these forums that you've been told, but you're saying that's the turning point in your case. As soon as you're told that now you're engaged in the trafficking.
Well, I think the moment they were notified this was sex trafficking, depictions of sex trafficking, a part of the sex trafficking ongoing scheme that was continuing, Twitter had a legal obligation to remove it at that point in time. Not only under the 1591 standard, but also under the 2252A standard. So they had an ongoing duty to remove it immediately. And if there was any doubt.
I think your case is much better on those claims. I really do. I think that, if you want to argue that these images were used by Twitter to, as Judge Van Dyke earlier pointed out, keep users tuned in, promote the platform, whatever the case may be, that's a viable question, which needs to be, I think, analyzed by the district court under Reddit. But claims 1 and 4, I think, in terms of trafficking of a person as pled, just go too far.
Well, Your Honor, I don't want to be remiss in not discussing our 2252 claims with the time that I have left. So I'm going to transition to those for a moment. Twitter did concede in their argument that if they were participating in criminal conduct, they would not receive 230 protection. And so by their own admission, they failed to receive 230 protection. The court had determined, the district court had determined that 230 was the reason that we could not proceed under the 2252A claims. And that is simply incorrect. We'd ask this court to overturn that because Twitter, at the moment they received it.
I'm sorry, I'm still processing. I didn't understand Twitter to say that just merely the fact that they might be doing something that was criminal conduct would mean they don't get 230 for a civil claim brought against them under the civil. It's just I understand them to be conceding is that 230 doesn't apply to actual criminal charges. That's what I understood them to be saying.
Well, even if we were to take it under how you understood it, Your Honor, and we were to look at it in that context, Twitter was in a position where they were notified that the criminal acts were being committed on their platform, that they were now in possession, had received into their database, and were in actual possession of criminal images, that it was a crime to possess. They had a moment in time when they had an obligation after they were notified to immediately report it to NCMEC, to immediately remove it from their platform. Instead, it took multiple days to review it. After verifying that all of that happened, they checked the Florida driver's license. They verified that the images were pornographic, as we've alleged in our complaint, and then they refused to remove it. That right there is a violation of 2255 and 2252A.
You started out by asserting that no court has ever found 230 immunity for pornographic images. I believe that's true in the criminal context. Is that true in civil cases as well?
Yes, no federal appellate court has found that. Your Honor, one of the things that I think is important to remember is that not only did Twitter possess it, they violated the statute of just mere possession, but then they disseminated it through their platform. CDA 230 protection is intended to protect people that are posting something and not hold a platform responsible for what originated from a third party and was then being held liable for the third party's posting. That's not what's happening here. It's the act of possession and the act of distribution that is the criminal conduct that Twitter participated in. I
think we're out of time, but I'll give my colleagues a chance to ask, but I have one question. You just said that, and I think that's right, that no federal court of appeals court has found 230 to apply to child pornography. In the district courts have addressed it. Real quick, what's the district court breakdown on that?
There is district court in.
It's like this district court said it applied. Like in this district court, you won, pre-read it on your claim, but that you lost on this claim. So this district court went the other way.
Our district court applied CDA 230. Other district courts outside of the Ninth Circuit have looked at this issue and have not been favorable. But respectfully, I believe those courts have misapplied the standard under CDA 230.
Are there any district courts that have gone in your direction?
No, I believe there's the Bates case, which was briefed by opposing counsel that talked about it in the other context. This really hasn't been addressed.
Make sure that we don't have any other questions. I mean, by the way, the briefing was very good. I think most of what you guys are saying, we're very aware of, and we've taken a close look at this case. So we're going to limit you to your 15 minutes each, but we're very, very aware of the case and take it seriously. Great advocacy by both sides. Thank you very much. And we'll take this case as submitted.
Thank you, Your Honor.
Okay? And if you're looking up at me, I'm going to show you something. See that right there? That's a sign of the alphas. So so if you don't understand that's for alphas, you say that's a gang sign, because it's going to depend on what clothes we got on and where we standing and who we standing by and when we do this. So officers see this, they say that's a gang, they dressed alike, they giving signs, they got signs on their clothes. Let's arrest them. That's what the bill does. I don't care about you talking about we trying to do this, do that. Remember I told y'all about the horses and the blinders? I'm going to say it a little different way for you to know the impact of what I'm saying. It's like an airplane going down, straight down the runway. You're just focusing, looking down the runway. Look at my arms. This is the wings of the plane. Watch this. I'm trying to walk through here. This is the wing. Bam, I knocked the mic over, head over. That's what you're doing to me. Because you don't know. You so focused on gang that get them that you taking all the folks that are somehow. You taking folks that make dress and have a hoodie on. I have clothes that have a hoodie on. If the wind blowing and it's cold, I have no hair. I must put the hoodie on. See the difference? I got the hoodie on because I ain't got no hair. My head cold. You got anything, anybody dress with hoodies on every game. Okay? They don't know what my face look like. Remember I told y'all in that store what happened to my son and I? That's the same thing gonna happen to me then. To me. Right now, at this age, I put the hoodie on. You pass the law. I go there standing at the service station. Quote, where the boys hang out. I'm the senator. They talking to me about
Senator Smitherman, time on the BR has expired. Senator Albritton.
Long roll.
All right, Senator Albritton.
Move for previous roll on BIR.
Long roll.
All right, Secretary, call the long roll. Mr. Albritton. Mr. Allen. Mr. Barfoot. Mr. Beasley. Mr. Bell. Mr. Butler. Mr. Carnley. Mr. Chambliss. Mr. Chastain. Ms. Coleman. Ms. Coleman Madison. Mr. Elliott.
You can't ask for both of y'all.
Ms. Figures.
You can't do that.
Mr. Gavan. Mr. Gudger. Mr. Hatcher. Mr. Hovey. Mr. Jones. Mr. Kelly. Mr. Livingston. Mr. Melson. Mr. Orr. Mr. Price. Mr. Reed. Mr. Roberts. Mr. Schofield. Mr. Sessions. Mr. Shelnut. Mr. Singleton. Mr. Smitherman. Mr. Stewart. Mr. Stutz. Mr. Wagner. Ms. Weaver. Mr. Williams. $26 ayes, no nays. The BR is adopted.
Mr. President.
Secretary, call the bill. On page 12 of the calendar, Senate Bill number 192 by Senator Albritton relating to industrial access roads.
Mr. President.
Senator Albritton.
Thank you. If I might explain briefly what my industrial access road bill does, so you'll understand what we're doing. This deals with allowing, right now we have the industrial access pot of money that allows for economic development and growth for the state to build or construct a road into the site of where a facility will be built, a manufacturing facility, a factory, or anything of that nature. Now, there's been times, ThyssenKrupp was one of those that occurred, and there's been several others where that occurred. They built in the road, and then subsequently there was an extension of that facility, and the owner had put in gates and security controls, so control people coming in and out, vendors and employees and such, for the safety and security. However, that resulted in the being declared that had become a public, that public road had become a private road, and therefore there was a clawback, if you will, of the monies that was used. We have the same situation that is occurring now in Baldwin County in a similar circumstance, and has happened in several different occasions. What this bill does is it simply adds the ability of a private facility to establish security on a public roadway. They can put a guard gate up, they can put a guard shack up, they can put other things there, but they have to do it under the authority of the local police. And then they can exercise that control for security purposes of the facility without causing a taking or a privatization of that road, so that the roadway will remain a public roadway, but the security will lie at the door of the facility under the authority of the local police department. That's all it does, is allow that security to be placed there. And with that, I'd invite questions.
Senator Smitherman, you're recognized.
Thank you. And Senator, I'll ask questions as long as you allow, and then when you get through, I'll just, if you get through, I don't mind, just keep on talking,
All right.
so
I'll be happy to respond to your questions, anything else.
thank you. I mean, they don't know.
Senator Smitherman, you have the mic, so it's your hour.
No, it's his mic. He just recognized me.
He just yielded to you.
No, he didn't yield to me. Did you yield? He didn't yield. I don't think he yielded to me. I think he said he'd entertain questions.
Mr. President, I don't think it matters at this point. I think Senator Smitherman and I are going to be discussing this bill as long as he needs and wants to discuss it.
All right, so Senator Auburn, you have the mic.
Thank you.
And a series of votes now on a bill that would ban transgender student athletes from playing girls and women's team sports at K through 12 public schools and universities that receive federal funding. Voting now on an
for their fair right to competition. And I reserve the balance of my time.
The gentlewoman reserves. For what purpose does the gentleman from California rise?
Mr. Chairman, I claim time to speak in opposition to the amendment.
You're recognized for 5 minutes.
Thank you, Mr. Chairman. This amendment perpetuates false arguments that allowing transgender girls to participate on school sports teams will undermine the well-being of cisgender girls. And again, my friends across the aisle are conflating and confusing the issue here. They want to talk about the struggles and the challenges we have with determining fair competition at elite sports. But what we're talking about here is a bill, the underlying bill, which would completely ban participation of all transgender kids across our country. And as I said, the example in Utah, 75,000 high school students competing in high school sports, 4 transgender kids, 1 competing as a female. This seems wholly disproportionate to the so-called problem. What's disproportionate is this proposal to completely ban transgender students from sports. Now, I want to say something here. The other side does not even want to acknowledge that transgender kids exist, that transgender people exist. Nevertheless, the legislation and this amendment target transgender kids, and they do it in a very insidious way. They'll say, oh, transgender doesn't appear in this bill. But let's not kid ourselves that the very intent is to harm and stigmatize, isolate, make them pariahs. And this is simply wrong. Look, I'm not a scientist. I was a English teacher most of my time before I got into Congress. I do know the harm that comes with this insidious use of language by not even granting the dignity of existing, not even granting the dignity of the existence of trans kids and trans people. That is what the other side is doing. It is going to be harmful. And how is it harmful? This mere debate has traumatized trans kids and their families across the country. 85% of transgender and non-binary youth say that the debates around anti-trans bills have negatively impacted their mental health. According to a 2022 survey, nearly 1 in 5 transgender and non-binary youth attempted suicide in the past year, and 45% of LGBTQ youth seriously considered attempting suicide in the past year. These statistics are real. They represent real vulnerable kids. And I urge my colleagues to oppose this amendment and to oppose the underlying bill, and I reserve.
The gentleman reserves. The gentlewoman is recognized.
Thank you, Mr. Speaker. For years, the left has said to follow the science. Well, today, Republicans are following the science. We are not conforming.
Good afternoon, everybody. What is that? Okay, I have a few things at the top today, so please be patient with me. This morning, the president convened the Major Economies Forum to galvanize global leaders into taking strong action against the climate crisis for the 4th time since taking office. We know that to tackle the current climate crisis, we need strong global ambition and stronger global action. That is why we continue to call on the world's largest economies who have the means and resources to implement green solutions to come together and discuss how we can collectively take steps to address this challenge. At today's meeting, President Biden announced that the United States will work toward limiting the rise in temperatures, including putting the power sector on a path to net zero emissions, reducing emissions and fossil fuel use by accelerating zero emission vehicle deployment, and decarbonizing international shipping. The president also announced significant new steps the United States is taking to support developing countries in taking stronger climate action, including providing $1 billion to the Green Climate Fund and requesting $500 million over the next 5 years from Congress for the Amazon Fund and related activities. And tomorrow, ahead of Earth Day, President Biden will announce additional actions to advance environmental justice and protect communities from the health and environmental impacts of climate change. He'll also highlight how Speaker McCarthy's extreme MAGA agenda would be a disaster for American families, killing all the manufacturing jobs created thanks to the Inflation Reduction Act, letting China outcompete us by us building the future of clean energy, and making it easier for big corporations to pollute the air that we breathe. We'll have more to share on tomorrow's event soon, but while I'm on the topic of Speaker McCarthy, I have more to say. As you all know, yesterday, Speaker McCarthy unveiled his plan to cut benefits for American veterans and take a 2x4 to America's manufacturing resurgence. Not only would the Speaker's proposal cut funding for our veterans, it would repeal the Inflation Reduction Act's investment in manufacturing in clean energy, investments that have created 100,000 manufacturing jobs, many of them in Republican-led states and congressional districts. The Speaker's plan raises crucial questions for dozens of House Republicans. Will they vote to kill manufacturing jobs in their own home districts and reverse the reshoring of manufacturing from China? And will they vote to cut benefits for veterans in their own districts? Will Congresswoman Majority Taylor Greene vote to eliminate the investments helping to create 2,500 solar manufacturing jobs in her district? Will Congressman Mike Carey risk the more than 2,000 electrical vehicle investment related jobs coming to his district? Which Republican members of Congress will back McCarthy's plan to cut benefits to veterans in their districts? President Biden has fought to create American manufacturing jobs and ensure our veterans get the respect and the benefits they earned, and he'll keep fighting for them. Even as Republicans in Congress put forward these proposals to cut jobs and benefits so the super wealthy and big corporations can enjoy a tax welfare. Now, on the other side of Capitol Hill this afternoon, Acting Secretary Julie Su had her hearing in front of the Senate Help Committee. We are working hard for every vote and feel confident about Julie's confirmation. She has a proven track record of working across the aisle, sitting down with the business community and organized labor, and delivering strong results for the American economy. That's why Julie was unanimously supported in her confirmation vote as Deputy Secretary of Labor by all Senate Democrats. And that's why Julie's nomination has been endorsed by a range of business groups, from Small Business Majority to the LA Chambers of Commerce, and labor leaders from the United Mine Workers to NABTU and Luna to IBEW. She served as Secretary Walsh's right hand for the last 2 years as they helped produce historic job growth and build strong relationships with both unions and employers as well. I also want to say a word about the decision yesterday made by the Florida Board of Education to expand the state's dystopian Don't Say Gay law. As this measure takes effect, it will prohibit all students up to seniors in high school from learning about or discussing LGBTQI+ people in the classrooms. Teachers in Florida have already faced the devastating consequences of the existing law. Under threat of having their licenses revoked, gay teachers have been forced to take down pictures of their spouses from their desks and censor their classroom materials. Censoring our classes is not how public education is supposed to work in a free country. Conservative politicians love to complain about the so-called cancel culture, all while threatening teachers with losing their jobs if they teach something that the MAGA extremists don't agree with. President Biden believes teachers and students should not be pawns in a political game or a political stunt. We will continue to fight for students across the country to receive a world-class education, including free from discrimination and also censorship. And finally, I want to speak to something else that urgently needs addressing in our schools, which is gun violence. 24 years ago today at Columbine High School, 12 students and a teacher were gunned down. Their lives ripped away in what was, at the time, the deadliest school shooting in American history. The massacre shook the nation, and it should have been our last school shooting. Instead, in the near quarter century that has followed, hundreds of thousands of American students have experienced gun violence in schools. In the United States, the #1 cause of death for children is firearms. Let me say that again. The #1 cause to children is firearms in the United States. This is a choice. If Republicans in Congress come to the table, if they were to come to the table, we can take action to end the epidemic of gun violence as we know it. The president is doing his job. He enacted the most significant gun safety legislation in nearly 30 years, and he has accomplished more through executive action to reduce gun violence than any other president in history. State legislators are doing their jobs. Yesterday, we saw in the state of Washington, legislature passed an assault weapons ban. Common sense measures are advancing in states such as Colorado and Michigan. Congress must do its job. Ban assault weapons and high-capacity magazine, require safe storage of firearms, require background checks for all gun sales, eliminate gun manufacturers' immunity for liability. We must move this country forward so that tragedies such as Columbine are forced into history books forever, and our nation's children can live without threat or fear of gun violence. All right, finally, thank you for your patience and bearing with me. I would like to welcome Admiral Kirby, the NSC colleague, to the podium. He's going to preview the President's bilat today with President Petro of Colombia and answer any other foreign policy questions that you may have. Admiral, the podium is yours.
Good afternoon, everybody. As Kareem mentioned, President Biden's looking forward now to welcoming President Petro of Colombia to the White House this afternoon, in fact, just about an hour from now. Colombia, I think, as you know, is a country the president has often referred to as the keystone to the region because it is a country that is emblematic of the optimism and the potential of the Americas, and one that has over more than 3 decades been characterized by strong bipartisan support here in the United States. The United States-Colombia relationship is a true partnership that spans trade, where we actually remain Colombia's largest trade and investment partner, but covers a wide spectrum of other issues that address our shared regional migration challenge, combating transnational criminal organizations, trafficking drugs, and of course, people. We are aligned in our ambition to address climate change, and we're working closely with Colombia to expand private sector investment in renewable energy. The United States is proud to support implementation of the ethnic chapter of the 2016 peace accord between the Colombian government and the Revolutionary Armed Forces of Colombia, otherwise known as the FARC. It's emblematic of our commitment to ensure equal access to opportunity and to promote prosperity in some of the communities that are most affected by violence. Colombia and Colombia's future, their security, their prosperity remains a national security interest of the United States. And during the conversation today, President Biden and President Petro will continue to make progress on these and many other issues. I also want to note just a couple of other things. You probably saw a readout that we issued. The president had a chance to talk to the European Commission President Ursula von der Leyen. They talked about her recent trip to Beijing. The president was interested in her perspectives being over there. They certainly talked about the need to maintain peace and security around and across the Taiwan Strait. Certainly, they talked about ongoing support for Ukraine and the fight against Russian aggression. And again, they talked about how we can together continue to work with our European partners for a clean energy transition. The president will also have a conversation later this afternoon with President Macron of France. He looks forward to that, and we'll have a readout for you when that's complete. With that, take some questions.
Great, thank you. So, John, thank you for being here. I want to start off by asking you about Sudan decision to send U.S. troops there. Can you update us on the status of the embassy and trying to get U.S. officials out of the embassy?
Yeah, so obviously we're still very concerned about the violence there, the continued fighting. There was a so-called ceasefire last night that didn't hold very long, and so people are still being hurt. What I can tell you is that we have good accountability of all our government personnel there working in and out of the embassy. They are all not still co-located, so the State Department is still, the embassy there is still trying to get them all co-located together for their own safety. They are still sheltering in place where they are. And as you probably saw, the Pentagon did announce that they are moving forward to pre-position some military forces and capabilities nearby, just for contingency purposes in case they would be needed for any kind of evacuation. But again, no decision has been made on that. The focus right now is on urging both sides to stop this violence, to abide by a ceasefire, to allow humanitarian aid to get to people that need it. I mean, there's already shortages of food. There's concern over shortages of medicine and water. The situation is dire in Khartoum, and we continue to urge both sides now to stop this violence.
What is the timeline for making a final decision and are sanctions on the table against these rival factions?
I won't get ahead of any sanctions decisions. I mean, we'll always look at a range of tools and capabilities that we have to try to compel both sides here to stop this violence. As for timeline, I think I'd refer you to the Department of Defense and the State Department on that. They would have to work in tandem here, but we want to make sure that we've got the capability ready in case it's needed. And again, DOD can speak to the timeline on that.
Thank you. Thank you, Kelly. And it's too early to point to Mr.
You're not used to getting the second question, huh?
Yeah, it's a easy idea and hard. Thank you so much. My friend Shine. Yeah. Thank you, Colleen, and thank you, John. I have a couple of occasions. South Korean president announced that South Korea would provide military aid to Ukraine if Russia launches a massive attack on the Ukrainians. How does the U.S. evaluate this? And I follow up that.
We would certainly let President Yoon speak to his comments and to whatever aid and assistance South Korea would want to give to Ukraine. We're grateful for the support that South Korea has already provided Ukraine in the tune of $100 million of humanitarian assistance. And of course, they've been very vocal in supporting Ukraine. They've been very vocal in speaking out against Russia's aggression. We're grateful for that. They're a terrific ally, terrific friend. And as I think you know, we're very excited to be welcoming President Yoon to Washington, D.C. next week for an official state visit, where I have absolutely no doubt that they will talk about a range of challenges, not just in the Indo-Pacific, but across Europe and in Ukraine.
Meanwhile, Russian Kremlin spokesman said that it will provide weapons to North Korea and warned that South Korea would pay the price. How do you view Russia's threat of retaliation against South Korea?
Yeah, look, I've seen those comments. I'll let Mr. Peskov speak for himself and speak for Vladimir Putin and the Kremlin here. I would just remind that we have a treaty alliance with South Korea. We take that commitment very, very seriously, and I'd leave it at that.
Thanks, John, so much for doing this. The U.S. has a lot of recent experience extracting embassy personnel both in Kabul and in Kyiv. How does this situation differ, or how similar is it to those? And what lessons has the U.S. learned from those experiences that can be applied here if necessary?
Well, I think just my answer to Kristen, I mean, if you might recall back in a couple of months before the evacuation out of Kabul, the president ordered the pre-positioning of military forces nearby so that they could be ready. And they were actually able to get onto the Karzai International Airport within 48 hours, and within 72 hours basically had control of it. Pre-positioning forces is not a new idea for the U.S. military, so that they can be ready. We want to be as close as you can get so that you can close down that time and space factor. It's a physics problem at that point, so you can be there as quick as possible. So certainly this is an outgrowth of things we've learned over the last year and a half, but it's also not something that the military is not used to doing.
It sounds also like it's an incredibly dangerous environment for anyone to drive around and be outside. Why the decision not to potentially provide military assistance to U.S. citizens who might need to flee Sudan and only direct that potential help to embassy personnel?
The focus right now is making sure that we've just got, let's not get ahead of where we are. The focus right now is just to pre-position military forces nearby in the region in case they're needed. No decision has been made to evacuate anybody. And what we said early on was that we advised Americans not to travel to Khartoum, not to travel to Sudan, and we made it clear that they should be making their way out of the country. So I don't want to get ahead of where we are. No decision to evacuate anybody now has been made. It's just really about pre-positioning military forces. If and when there's a decision to move towards some sort of military evacuation, then we'll have more to say about that at the time in terms of size, scale, scope, and what we're doing. But right now, the best thing that can happen is for the fighting to stop, for the two sides to lay down the arms, to abide by these ceasefires they keep saying they're committed to, and let humanitarian aid and assistance, food, water, medicine, get to the people of Khartoum who are growing increasingly desperate for it.
Thanks, Kareem. John, President Petro came to the White House today saying that his message on Venezuela is less sanctions, more democracy. Yeah. But Nicolas Maduro says that the sequencing of that has to be sanctions relief followed by democratic progress. What's the U.S. response to it? What is the president going to be saying to Petro?
We've long been clear that we would review our sanctions policies in response to constructive steps by the Maduro regime, and if the Venezuelan parties can make meaningful progress in return to a democracy in the country. Well, I think we've also been very, very clear that we're not afraid to take action should the Maduro regime fail to negotiate in good faith or to follow through on its commitments.
Could you talk about how President Biden has been involved in this discussions about Sudan? Was he briefed on the deployment, the positioning of these military forces?
Yes, he was. He's been obviously following this very, very closely, the events in Khartoum and in Sudan. He has been in touch with his national security team regularly since the violence started, and he authorized the military to move forward with pre-positioning forces and to develop options in case And I want to stress right now, in case there's a need for an evacuation.
And when did he authorize that, today or yesterday?
This was in the last couple of days.
Jeff, and then we'll go to the record.
Thank you. John, you mentioned the state visit next week. To what extent do you expect China and North Korea to be discussed during the president's meeting with his counterpart? And on the same issue as China, the Major Economies Forum, or excuse me, on the same topic, the Major Economies Forum happened today. The Chinese climate advisor was there. Can you give us any update on what he said with regard to their plans on methane or other climate change policies?
I would refer you to the Chinese authorities, the PRC, to speak to whatever their comments were or how they phrased it. But as Karine noted in her opening statement, I mean, the Chinese are moving out and moving out aggressively on the transition to clean energy. And when you look at the strategic competition that the president believes that we're in with China, and we do want to keep it on competition and not conflict, this is an area where the United States can absolutely compete and win, because of the innovation here in the United States of America and the opportunity that we have before us to really grasp onto a clean energy transition. Because there's not only is that good for the climate, it's good for our economy because it'll mean more jobs. So this is absolutely an area where we can compete with them. Now, on your first question, I know of no conversation that we ever have with our allies in the Republic of Korea where we don't talk about the threats posed by North Korea to the peninsula and to the region. And I know of no discussion that we have with those very important allies where we also don't talk about the challenges posed by China in the region and globally. And I fully expect that both will be matters of discussion.
Thank you,
John. Right over here. One on Russia and one on Mexico. On Russia, there was a hearing up on the Hill yesterday, and we heard from the prosecutor general from Ukraine, and he had asked the United States to designate the Wagner Group as a foreign terrorist organization. Does the White House believe that group should reach that designation?
We've made no such determination, and I have nothing to preview for you on that. But make no mistake, this paramilitary contractor that Mr. Putin increasingly relies upon is certainly continuing to try to take back Bakhmut, for one thing, and they're continue to throw bodies, a lot of prisoner bodies, at that fight. Mr. Prigozhin clearly has some personal gain here at stake in wanting to take back Bakhmut, not only for his personal prestige and a way to try to maybe embarrass the Russian Ministry of Defense, but also for perhaps his own economic gain, since there's a gypsum mine there. Not entirely clear, but he looks like he's got more than one motive.
And on the issue of Mexico, U.S. prosecutors within the past week here announced the arrest of 28 members of the Sinaloa cartel. And Mexican President AMLO described that as spying and as interference. He said it was abusive, arrogant interference that should not be accepted under any circumstances. I guess, what is your reaction when you hear something like that? And generally speaking, how can the U.S. rely on Mexico as a partner in the fight against the cartels when an arrest like that is viewed as a negative?
I'll certainly let President Lopez Obrador speak to his comments. And broadly speaking, I'd refer you to the Justice Department on this. But the president had a great discussion in Mexico City with both President Lopez Obrador and Prime Minister Trudeau about the need to continue to put pressure on drug traffickers and the cartels. And what you're seeing here out of the Justice Department is a step in that direction here by this administration. We're going to keep doing that because it's that important to the safety and security of the American people. And we're also going to keep having these discussions with our counterparts, particularly in Mexico, who likewise suffer from the activities and in some cases the unimpeded activities of these cartels in Mexico.
Thanks, Karine. Good afternoon, Admiral. I apologize. Okay, if I took someone's turn, I apologize. I'd like to ask about the genocide against the Uyghurs in China. It's been declared a genocide by the U.S., as you well know. Representative Smith of New Jersey, he just wrote to China's president himself asking to visit Xinjiang. Smith says he wants to see for himself what's going on concerning mass detention and forced labor. Simply, what's the administration's reaction to that request by the congressman?
Members of Congress are entitled to travel where they want and ask questions of whoever they want. We don't take a position on their travel.
Just to follow up on that, more broadly speaking, the world promised to never let a genocide like the Holocaust of World War II happen again. We have a Holocaust museum right down the street. Does the administration believe there's enough urgency right now in helping the Uyghur Muslims?
I think this is the kind of thing, whether it's the Uyghurs or elsewhere around the world, but where we have to continue to apply constant and unrelenting pressure to protect basic freedom of worship and human and civil rights around the world. It's not something you can ever let off on, and it's not something that, we snap a chalk line and say, we're done, and we fixed it, and it's over. It's the kind of thing that we're constantly working at.
Japan's our greatest ally. It hosts the largest number of U.S. military of any country in the world. And there's a lot of concern about this recent spate of leaks. Can you update us on if that is able to track down what happened and an assurance for the future that the conversations will be protected?
You're talking about the documents. Look, again, there's criminal investigation going on by the Justice Department. You've seen work out of the Pentagon to already restrict some access, and the president has asked state Department of Defense and the intel community to take a broad review of security protocols, practices, and procedures to make sure that they are appropriate and that we're not missing something that we should have caught. But I don't want to get into speculating about what happened here. All I can tell you is we're taking this seriously, and across the interagency, we're taking steps to make sure that the protocols and procedures are appropriate.
I know we keep bringing this up, but
Support for TVW Web Services provided by Virginia Mason Franciscan Health.
The House will be in order if members can take their seats. We will resume consideration of the motion to concur in the Senate amendments to substitute House Bill 1240. Remarks? Seeing none, the question before the House is whether to concur on Senate amendments to substitute House Bill 1240. We will proceed to an oral vote. All in favor say aye. Aye. Opposed say nay. The Speaker will divide the House. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Have all members voted who wish to vote? Would any member like to change their vote? The Speaker's about to lock the roll call machine. Speaker has locked the roll call machine. Speaker will announce the vote. The clerk will announce the vote.
Madam Speaker, there are 50 ayes, 40 nays, 0 excused.
The motion is adopted. Final passage of substitute House Bill 1240 as amended by the Senate. Remarks? A good member from the 21st, Representative Peterson.
Thank you, Speaker Orwell. Requesting your affirmative vote on substitute House Bill 1240. This piece of legislation has been on quite a journey, notwithstanding even the last couple of hours with this last little delay. Speaker Orwell, as you know, I first introduced similar legislation in 2017 after the horrific shooting in my district, and thank you for your support through the years. And these incidents are still happening all around the country. Speaker Orwell, we are in our 101st day in this great legislative session, and we have been doing incredible work. But in that 101 days nationally, there have been more than 101 mass shootings. Now, I don't propose, and I don't think you believe either, that this bill is going to end that scourge of gun violence across the country or in our state, but it's going to do something. It is going to slow the proliferation of these mass gun violence incidents that have taken place in our schools, in our grocery stores, in our neighborhood banks, in our movie theaters. We have to do something, Speaker Orwell, and I appreciate all you've done in the space of mental health, in the space of crisis aversion, and that is part of the solution, absolutely. But this piece of legislation is also part of that solution. Again, I appreciate your support through the years and ask for your hopefully final affirmative vote on House Bill 1240. Thank you very much.
Thank you. Additional remarks. The good member from the 19th, Representative Walsh.
Thank you, Madam Speaker. The right of a citizen to keep and bear arms in defense of himself and of the state shall not be impaired. Madam Speaker, please vote no on House Bill 1240. This proposal is constitutionally flawed and in the end will not prevent harm, will not prevent one mass shooting, will not prevent any of the risks, gun-related or otherwise, that the people of Washington face. What it will result in, Madam Speaker, if it's passed and signed into law, is a waste of taxpayer time and money. Madam Speaker, the lawsuits challenging this proposal on constitutional grounds are no doubt readied to file. And if the governor signs this bill into law, those lawsuits will be filed as quickly as the ink dries. And in light of the U.S. Supreme Court's recent Bruin decision out of New York, this kind of policy, exactly this kind, a state bill or law that infringes or impairs your right to keep and bear arms in defense of yourself and the state, have been ruled unconstitutional. And of course, in the Bruin decision, the U.S. Supreme Court gave specific instruction to the lower federal courts to reconsider any of their opinions that had allowed states to pursue these kinds of policies. Madam Speaker, the path is well lighted on how this is going to go. It's largely known. And the part that I believe really drives the no vote is the amount of taxpayer resources that will be consumed walking this path. Please vote no, and let's work together on better policy that actually makes Washington safer.
Thank you. Additional remarks. The good member from the 35th, Representative Couture.
Thank you, Madam Speaker. The good gentleman from the 19th spelled it out really well. This bill is unconstitutional, and I believe that we are wasting a lot of time and resources to go down this path. What's upsetting to me is how there was an amendment in the other body that recognized those who were in the military or are in the military. Madam Speaker, I moved out to this great state with the United States Navy. I had, the possessions in my sea bag, and I put them in my car, and I drove across half of this country to get here and to serve for 5 years on submarines and to do the mission that our country told me I needed to do. And to say to those members of that military community that you can't bring your lawful possessions, including firearms, with you if they're subject to this bill, which there is many, Madam Speaker. I believe that's wrong and that's disparaging to military people that would come to our state to serve our country all across the United States. That's not welcoming, that doesn't respect their private property, it doesn't respect their Second Amendment constitutional rights, or even the constitutional rights that we have in our own state's constitution, Madam Speaker. We should have had that amendment, but we don't. And now, as military members come to our state to serve our country, whether it be in the Navy, Air Force, Army, Marines, the Coast Guard, you name it, now they can't bring their possessions with them. They have to what? Check it at the border of Idaho or Oregon? So that I don't honestly understand why we would do such a thing to those people. We should be welcoming them.
Please focus on the policy, not impugn members. Please proceed.
We should be welcoming those people with open arms, Madam Speaker, including the possessions that they bring with them, and we should respect their constitutional rights. Please vote no.
Thank you. Additional remarks? The good member from the 16th District, 15th, Representative Sadlin.
Thank you, Madam Speaker. I rise in opposition to this bill. Substitute House Bill 1240 doesn't accomplish what the intended purpose is. It's a bad bill. Please vote no. It does not fund education. House Bill 1240 does not solve crime. House Bill 1240 does not help the homeless. House Bill 1240 will be overturned. I'm not a lawyer, but I feel the words of the good members that have spoken before me are true, and it will be overturned. So consequently, it's been a big waste of time. We have better things to do with our time, Madam Speaker. Please vote no.
Thank you. Additional remarks? The good member from the 6th District, Representative Graham.
Thank you, Madam Speaker. I'm rising in opposition to this bill. Also, as a veteran, I'm wondering what this is going to look like nationally. We're going to make national news yet again for all the wrong reasons. Madam Speaker, disarming good people that are not breaking our laws is not going to do anything to stop the people who have either hate in their heart or evil intentions. It is something that common sense is coming around to talk about what we're seeing with what's going on with crime. Madam Speaker, I'm going to talk about the hypocrisy. Again, we are punishing people who have not committed any crimes, but at the same token, we're also seeing steps taken where if somebody that is a known criminal does use a firearm to commit a crime, there's been policy that's clawed back any sort of accountability for those actions. If we talk about school shootings, again, Madam Speaker, it's hypocrisy when we're going to go after somebody that has not committed a crime, but yet the person that would go into our school to do this, or a stadium or a grocery store, and they get a less penalty when they're the ones that actually commit the crime, doesn't make any sense, Madam Speaker. And in other states that have stronger firearms laws than we do, their rate of crime, murder, people being hurt is actually higher. Madam Speaker, when we're talking about soft targets, like our schools, like grocery stores, places that do not have armed security, those are the places that are more likely to have something happen. Madam Speaker, there was a shooting in Nashville, and the individual that committed that crime actually had a manifesto that talked about more than one place and decided not to go after the one other place because they were worried about there being somebody else armed in which they might be hurt or killed. So they went for the soft target instead. Madam Speaker, we need to do a better job with this. We need to protect our kids, but we also need to hold the people that commit these crimes accountable. Thank you, Madam Speaker. Vote no.
Thank you. Additional remarks. The good member from the 20th District, Representative Barno.
Thank you, Madam Speaker. And I also rise with many of my colleagues in opposition of this piece of legislation for maybe a second or third time when it came through this chamber the first time. This piece of legislation, as you've heard, Madam Speaker, the arguments of the constitutionality and the fact that I believe that this legislation will be challenged almost immediately upon its signing and ultimately will be found unconstitutional based on a number of recent cases that we've discussed on this House floor. I also rise in opposition of this piece of legislation because of the impact on so many in my community who embrace the history and tradition of hunting and shooting sports and all of the other aspects that will be impacted by this law. We talked about some of the great shooting teams in rifle clubs in Centralia, Chehalis, and throughout the state of Washington, some winning awards in their competitions that will be impacted by this piece of legislation. And I'd also bring up the fact that this piece of legislation and the restrictions it has on law-abiding gun owners is not going to the root of the problem. The root of the problem is not those who use firearms to protect their homes and families, as we know with the massive rise in crime, both property, but most certainly violent crime. But it also really flies in the face of the policies that this body has passed even today. Today, we voted to eliminate victim impact fees. Those fees that are charged to people who commit crimes against victims. Earlier in this session, we voted to remove sentence enhancements for criminals who commit crimes in protected zones like near school buses, schools, civic centers. This policy is trying to reduce crime based on its intent language. However, it goes after law-abiding citizens, and it's not going after the people who are actually committing the crimes. The policies that would directly reduce crimes are the policies that we had a chance to pass but chose not to, like making sure that when you commit a crime, you pay a victim impact fee so those victims are made whole, that those criminals are held accountable if they commit crimes near our children and our schools. This policy does none of that, and that's why I'm urging a no vote.
Thank you. Additional remarks. The good member from the 25th, Representative Jacobson.
Thank you, Madam Speaker. My no vote is for the vulnerable in our society. It's for the victims of domestic violence. It's for people who need to defend themselves. These are the law-abiding citizens that are protected by our constitutional rights. My no vote also, Madam Speaker, is a deeply felt belief that this is not going to do what we hope it will do. We need to make sure that we have sentencing enhancements, for instance, for crimes with guns. We need to make sure that we are careful about how we structure the physical places, our schools that our children go, and how we build them. We need to make sure that we have mental health care and that we have places for we have sanctions for crimes that are committed that are appropriate, and we need to make sure that we allow our police to pursue criminals. So by voting yes on this, I hope that those voting yes, I hope that we don't pick our...
Please don't speak to the yes vote. Please speak to the policy. Please proceed.
Thank you. I'm sorry. I hope we don't take our eye off the ball. I hope we do the things that are needed in this society to get crime down to better levels. And I hope that we realize that this will not do what we hope it will do. Thank you, Madam Speaker.
Thank you. Additional remarks. The good member from the 4th District, Representative Christian.
Thank you, Madam Speaker. Appreciate the opportunity to talk. Bad bill, vote no. Madam Speaker, guns do not kill people. People kill people. I have several weapons. None of those weapons have ever killed a person or have even been trained on a person in defense. But the fact that I have them makes me feel secure that I can protect my family. Madam Speaker, a little over a year ago, there's a country that was invaded by another. And as we watched the news reports, they were training their people with cardboard cutouts of guns and sticks and practicing maneuvers, hoping and dreaming that they had a weapon. Madam Speaker, America is a safer place today because law-abiding citizens, members who are retired or in active duty in the military, we have been trained. We will defend this country to our dying breath. But we need the tools to do it, should that ever happen. And Madam Speaker, this bill just makes our state and our country less safe because we're criminalizing the good men and women who are good law-abiding citizens and allowing the criminals, the ones who cause these atrocities across our country, the mass shootings in schools. These are not good law-abiding citizens. These are people with serious issues, and we're not dealing with the issues. We're taking away the accountability for them and instead attacking the good citizens of this country with laws like this one, Madam Speaker. Madam Speaker, I urge you to vote no on this bill for all the good people of this country who care about this country and are willing to stand up, whether they're in the active military or neighbors gathering together to stop another country from invading us. We would give thought to those other countries if they thought they could take over America, because we would all be on the shore, and you would certainly hope that we all had our guns to protect this country. Thank you, Madam Speaker.
Thank you. Additional remarks. The good member from the 13th, Representative Dent.
Thank you, Madam Speaker. Every 2 years, when we're elected or re-elected, we come in this body, into this chamber, we're given the oath of office to uphold the Constitution of the state of Washington. And the Constitution is pretty clear on this. The state of Washington, it's actually more clear than the federal Constitution, but the right of the individual, to bear arms in defense of himself or the state shall not be impaired. That's pretty clear. Yet we just keep we keep chipping away at what our firearm rights really are. And this is one such thing that we're doing. It bothers me from the point that this is a bill that came forward without collaboration. It was similar to what we heard last year. We didn't work on this as a body together. At least 40% of this body is going to vote no. That's we should be working on things if we want to solve issues. The number one issue, Madam Speaker, and I have talked about this many times, the mental health in this country is staggering, the mental health issues. And everyone who we find that goes off on one of these shooting sprees, what's the common denominator? It's mental health issues. Well, you know, just from this country boy's pragmatic approach, it looks like we ought to be working on mental health issues so we don't have these people doing these things. Substance abuse, another big issue in this country. Yeah, we heard a bill the other night that kind of weakened some of the things that we do around folks that are struggling with substance abuse. And I can tell you from my experience, next month I'll be 36 years sober, that you don't fix people with substance abuse by coddling them. You fix them with consequences. But we're not doing that. But we're going after a symptom. And this is a symptom. I really wish we could go after the root cause. I do. That's what troubles me that we're not doing. And I watched the movies today. The movies are just despicable because life is taken so nonchalantly. Madam Speaker, this is a bad bill. Please vote no.
Thank you. Additional remarks? Seeing none, the question before the House is final passage of Substitute House Bill 1240 as amended by the Senate. The Speaker is about to open the roll call machine. The Speaker has opened the roll call machine. Has every member voted? Representative Ortiz-Self, would you like to vote orally?
It's been hitting the spot for the workers of Monterrey for nearly
Representative Ortiz-Self, would you like to vote orally?
And plan your visit. Go to Expedia.com/explore Mexico.
Would any member like to change their vote? The Speaker's about to lock the roll call machine. The Speaker has locked the roll call machine. Clerk will announce the record.
Madam Speaker, there are 56 yeas, 42 nays, 0 excused.
Having received a constitutional majority, Substitute House Bill 1240, as amended by the Senate, is declared pass. We will consider the following bill. Engrossed Substitute House Bill 1853, hearing no objection, so ordered. Engrossed Substitute House Bill 1853, message from the Senate. Clerk will read.
Madam Speaker, the Senate has passed engrossed Substitute Bill 1853. Colleen Russ, Deputy Secretary.
If there's no objections, the House does not concur to Senate amendments to engross Substitute House Bill 1853 and asks the Senate to recede therefrom. Hearing no objections, so ordered. With the consent of the House, engrossed Substitute House Bill 1853 will be immediately transmitted to the Senate. Hearing no objection, so ordered. We will now consider the following bill, engrossed Substitute House Bill 1436. Hearing no objection, so ordered. Engrossed Substitute House Bill 1436. Message from the Senate. Clerk will read.
Madam Speaker, the Senate has passed
Last line.
Substitute House Bill 1436. Colleen Russ, Deputy Secretary.
The good member from the 31st, Representative Stokesbury.
Thank you, Madam Chair. Madam Speaker, I move to concur in the Senate amendments to engrossed Substitute House Bill 1436.
It's been moved and seconded that the House concur in Senate amendments to engross Substitute House Bill 1436. Remarks. The good member from the 31st, Representative Stokesbury.
Well, thank you, Madam Speaker. That is fun. I know why the gentleman from the 23rd gets to do that so much. Madam Speaker, I am recommending that we concur with the amendments that came over from the other side of the rotunda. I think it's hopefully no dispute that this body needs to do more in the area of special education funding. The bills that have passed this House floor on this topic have been pretty bipartisan and strongly supported, and I think that's good. I think that's going to continue. But the difference, Madam Speaker, is exactly how we achieve that goal, and more importantly, how quickly we achieve that goal. I think the bill that came over across the rotunda is better for a couple reasons. One, it increases the multiplier by a higher amount, so that's going to give school districts more funds with which to deliver IEPs to kids in special education programs. Secondly, it is going to raise the cap more rapidly. So while it's true that the version that this body might otherwise prefer would eliminate the cap, the bills that have done that have only done so by deferring the elimination of that cap 4 or 5 years down the road. I think we need to do more faster, and the bill that is now before us, if we concur with the other body, would do that. It would increase the cap much more quickly than the bill would increase the cap that we have passed off this House floor before. And lastly, Madam Speaker, another really important change that is included in the bill from the other body is a new innovative idea to provide advocates to help parents and kids navigate the special education system. We know that a huge determinant of a kid's education success is involved parent, but that's not really something you can easily legislate and mandate. And so for kids who aren't so fortunate to have parents that are involved, you know, whether that's just because of lack of interest or lack of understanding or lack of language access, this bill, as it passed the other body, and if we concur, it could pass this body, would provide folks to help kids and their families navigate that complicated environment. So, Madam Speaker, I'm glad that I think, are likely to agree that we should increase funding to special education, but I think if we concur, we can provide more funding to special ed by raising the multiplier by a higher amount, raising the cap more rapidly, and providing kids and families with folks to help them navigate the special education system and obtain the best outcomes for their kids. Please vote yes on this concurrence motion, Madam Speaker.
Thank you. Additional remarks. Representative Bergquist to speak in opposition to the motion. Please proceed.
Thank you, Speaker Orwell, urging a no on this motion. I appreciate the thoughts from the good gentleman, but I think that sometimes not just this side of the rotunda have good ideas, both sides have good ideas, and we like to merge those ideas into one piece of legislation. That's what we're doing here today is
I'm here to talk about a young man by the name of Lakeith Smith. Lakeith Smith is 15 years old. He lives right here, where he used to live here in Montgomery. He got in trouble in Elmore County. He went before I'm gonna tell you what exactly happened. So him and a couple of his friends, he was 15, went inside a house and they broke in. Police was called, police come out. Lakeith gets shot. Not Lakeith, his friend gets shot. So Lakeith is there. So they charge him, you know, we got that law. So they charged him for his murder. And before they charged him with his murder, they offered him like 30 years. So his mom was like, okay, well, we're gonna go to, and he's 15. We're gonna go to trial because my son actually broke in, but he didn't rightfully kill someone, right? So that's what happened. But in the same courtroom, and one case was heard on the exact same day, Remind you, Lakeith is 15. So we have a man, he killed a 3-year-old girl, grown. He beat her. He hit her, had seizures, and he only received 15 years and 1 day for a 3-year-old that he actually sent into seizures. Then we have another guy who was in court on the same day Lakeith was in court. He was 28 years old. He killed his girlfriend. He was a sex offender and he was on drugs. He received in the same day 3 years. Lakeith again broke in. His friend broke in. Friend was killed by the police and they charged him with it. But however, he never pulled the trigger. Am I condoning breaking in? No, just fairness, because this is what we're talking about, being fair. The exact same day that he received 3 years, Lakeith received 65 at 15 years old. Now, we all know we made mistakes. Some of us are a little different than others. Some of us got a little pull where we'll maybe get pulled over, have some stuff, and know some people, or in small counties where everybody know everyone. And you are gonna take that child to their parents, right? Mom and dad. get ready to knock his head off when he come in the house, because you know not to be breaking in somebody's house, whether it's their house, their cars, or anything else. But for Lakeith, that didn't happen. Lakeith Smith. Right now, he's been locked up for a long time, for an extensive amount of time, for a 15-year-old. And if you saw his picture, I mean, good God. He looked like he was about 12 or 13, but he was actually 15. But could you imagine being 15 charged with your friend's murder that you didn't pull the trigger on and get 65 years at 15, and a grown man at the age of 27 who deliberately killed his girlfriend received 3 years in prison the exact same day that you go to court? Now, the other two gentlemen, we don't have to talk about their nationality because we're going to already know what their nationality is compared to Lakeith's nationality. So I just wanted to, and every chance I get, I'm going to come down and I'm going to say the exact same thing until we actually hear what's taking place in, not just in Alabama, but across the U.S. Unfairness. And we always say due process or justice is blind. Justice can't be blind because justice are eyes, and it's human eyes. It's human eyes with human thoughts, with human perspectives. And we all don't have the same perspective. Some of us in here don't have the same ideology about life, how we operate day to day, what we're doing, our family and our friends, our upbringing, our culture. A lot of us don't have that. Some of us have a good face for the State House, right? We have a good face. We come in, we smile, we look at each other, we pat each other on the back. And then when we go home to a different type of environment where we do the things that's not it's considered not to be appropriate. However, it's considered to be appropriate culturally.
From the House amendment to substitute House Bill 1240. Remarks, Senator Peterson.
Thank you, Mr. President. We would like the bill to go forward, but obviously cannot with the amendment that is outside of the scope as determined by the other body. So we plan to do some work on the bill this afternoon.
There are no further remarks. The question before the Senate is the motion to recede from the Senate amendments to substitute House Bill 1240. As many are in favor will signify by saying aye.
Aye.
Opposed, no. The ayes have it. The motion carries. The Senate has receded. Senator Peterson.
Thank you, Mr. President. I move that the rules be suspended and that substitute House Bill 1240 be returned to second reading for the purpose of amendment.
Senator Peterson moves that the rules be suspended and substitute House Bill 1240 be returned to second reading for purposes of amendment. Remarks? Senator Peterson.
Well, thank you very much, Mr. President. We had so much fun with this debate on Holy Saturday that we thought we would try to do it again before the end of session. Urge your support.
Further remarks, Senator Nobles.
Thank you, Mr. President. I move to excuse Senator Saldana.
Hearing no objection, Senator Saldana is excused. Question before the Senate is the motion by Senator Peterson to suspend the rules and return substitute House Bill 1240 to second reading for purposes of amendment. As many are in favor will signify by saying aye. Opposed, nay. The ayes have it. The motion carries. Substitute House Bill 1240, the Secretary will read.
An act relating to establishing firearms-related safety measures to increase public safety. RCW.
Amendment at the desk, striking amendment number 0445. The Secretary will read.
Strike everything after the enacting clause and insert the following.
Line.
Effect immediately.
Senator Peterson.
Thank you very much, Mr. President. I move that Amendment 0445 be adopted.
Senator Peterson moves adoption of amendment number 0445. Amendments to the amendment. Amendment 0451, the secretary will read.
On page 13, line 10, after
Last
any,
line.
insert state or.
Senator Wagner.
Thank you, Mr. President. I move to withdraw the amendment.
Motion not required. Hearing no objection, amendment number 0451 is withdrawn. Further amendments, amendment number 0446, the secretary will read.
On page 13, line 11, after agency,
line.
insert. On page 13, line 18, after agency, insert or its employees.
Senator Short.
President, I move for adoption of Amendment 446.
Senator Short moves adoption of amendment number 0446. Remarks, Senator Short.
Thank you, Mr. President. Bring this amendment forward. For folks that aren't aware, law enforcement officers in the line of their duty are able to private purchase weapons for their use in their law enforcement capacity, Mr. President. There are manufacturers that we are aware of that specifically manufacture weapons to the specifications for law enforcement individuals. They use them in the line of duty, but it is a private purchase, And I think if I look at the striking amendment, it talks about, again, firearms that are already owned, taken out of the state and come back into the state. And to me, this is something that makes sense to accept, and to allow, this amendment would allow that to continue. I'd urge its support. Thank you.
Further remarks, Senator Dingra.
Thank you, Mr. President. Rising in opposition to this amendment, the underlying bill under Section 3 clearly states that you can offer to sell to any law enforcement agency for use by that agency or its employees for law enforcement purposes. So if you are using it for law enforcement purposes, it can be sold to the agency for use by the individual when it is within the scope of their work responsibilities. So asking for a no vote on this amendment. Thank you.
Further remarks, Senator Fortunato.
Thank you, Mr. President. A lot of police officers buy their personal weapons. This is a personal sale that they then use during their actions as a police officer. So this amendment clarifies that, and urge your support. And again, we want to pass laws that are clear, Mr. President. Thank you.
Senator Nobles.
Thank you, Mr. President. I move to excuse Senator Mullet.
Hearing no objection, Senator Mullet is excused. Further remarks, Senator Rivers.
Thank you, Mr. President. I have the pleasure of having in my employ in my real job an individual who retired from a police force. And one of the processes that I found out about was this idea that you can purchase your service weapon after you leave the force. Now, I don't think you'll argue with me that if you are on a police force, you've done significant training, you have met the standards, and so you are well able to handle your weapon and understand the respect that it requires. So when I asked my employee why it was so important to have the service weapon, they responded that it had been at their side for 27 years and it just felt wrong to not have it. So when I look at it from that perspective, it seems to me they're leaving the force. So the section that was cited a few moments ago will not pertain to this individual because they're no longer employed by a police agency. So I think this is a great amendment that allows these people who've put it on the line to keep their community safe to have the weapon that they had held for many years. Thank you, Mr. President.
There are no further remarks. The question before the Senate is adoption of amendment number 0446. As many are in favor, will signify by saying aye. Opposed, no. The noes appear to have it. The noes have it. The amendment is not adopted. Further amendment, amendment number 0448. The secretary will read.
On page 13, beginning in line 31, after D, strike all
Last
material.
line.
Limited period of 90 days after the effective date of this section.
Senator Patton.
Thank you, Mr. President. Move that amendment 0448 be adopted.
Senator Patton moves adoption of amendment number 0448. Remarks, Senator Patton.
Thank you, Mr. President. This amendment deals with a licensed firearms dealer, and it would simply authorize that dealer to sell or transfer their some call assault weapons, some call other things acquired prior to the effective date and up to 90 days after the effective date of this bill. Mr. President, there are over 1,000 firearms dealers in our state. They employ a number of people. They have a huge economic impact, and they are a lawful business in our state. Any other lawful business that was trying to liquidate would probably take 6 months. Here we are modifying that to 90 days to allow them to transfer this product to people. Otherwise, they're going to take a loss. And I know some folks in here may feel, so what? We really don't like that business, even though it's a lawful business. We don't like them. We don't care if they lose money. But I would hope that is a very, very small percentage, if any, of the members on the floor, and that they would want to have an orderly transition opportunity. During committee, I indicated when my father, who is now deceased, said he had a steel warehouse business, and he worked on that right up until he died, and he gave specific instructions to my little sister, who was running the business, on how to liquidate. And he would have a certain price for a certain period of time, and if the product didn't sell, then he would lower the price a little bit. But it took a period of time to get the value that he thought would work, and that those instructions were very good instructions. My sister followed them, and they had an orderly liquidation of the business. So that's what we're asking for here, Mr. President. Would urge the body's support. Thank you.
Further remarks, Senator Dingra.
Thank you, Mr. President. Rising in opposition to this amendment, and I think we all want to be very careful on exactly how we're impacting our small businesses, because I think I can say very, very clearly, we all want all our lawful small businesses to be successful. They're important to our economy. We want to make sure we're doing right by them. This amendment, however, is extremely broad, and we're not talking about someone liquidating their business. This is one product we're talking about, is assault weapons. We're not talking about all the other products that are sold by a business. So this is not about liquidation or closing a business for good. This is basically saying the underlying bill has this amendment that says if you have inventory, you can actually sell it for 90 days to individuals out of the state of Washington. And yes, the underlying bill does say that you've had to have had it in your inventory before January of this year, but you have the ability to sell it for 90 days to individuals outside of the state of Washington. So that's already in the bill. We also provide in the bill that individuals can continue to sell to law enforcement agencies, to branches of our military. So there are options on making sure that you can sell your inventory. And we also have our larger businesses that may have stores outside of the state of Washington. They can absolutely transfer these products outside of the state of Washington. So I just want to be very, very clear. We all support our small businesses. No one is, they're not closing down and getting rid of all the products. We're talking about one product here. And we already have options for how these small businesses can make sure they can transfer or sell the inventory that they've had before January. So asking for a no vote on this specific amendment. Thank you.
Further remarks, Senator McCune.
Thank you, Mr. President. Well, we're really not talking about one product. We're talking about multiple products. There's not just one semi-auto shotgun we're talking about. We're talking about lots of them. We're not talking about what you call assault weapon, not you per se, but what you call assault weapon. We're not talking about one. We're talking about a lot of them. And there's not one store. It's not like walking into a big box store and they got rifles on the shelf, they got pistols lined up, they got bullets all over the shelf. The small shops aren't like that. They're specialty shops. Sometimes you go in and they sell mostly rifles, not necessarily pistols. They do repair on the rifles and stuff. So we're not talking about that. And there's a lot of these in my district that are going to go out of business, no doubt about it. And the competition, if you know anything about buying weapons or guns, competition is heavy all over the U.S., online buying. And so out of state, I don't think they're going to sell any of these out of state. Maybe they will, a couple, but they're not going to sell them. They're going to sell them in state. And that's what we're asking here, in state. And they need to be able to sell their products off. And again, I reiterate, I told a story on the floor, and the guy said he's absolutely going to go out of business because his stock and his is all in rifles and semi-auto shotguns, and he repairs them. So you're wiping out his business totally. So that's absolutely not true. Thank you, Mr. President.
Further remarks, Senator Wilson Linda.
Thank you, Mr. President. I just was looking at the bill and actually counted the amount of firearms that was included, and at least there's 65 at least listed here, and then an exhaustive list of how many, the description of others that would be included. So we're not talking about one product. We are talking about many. So I just want to make that clear. Thank you.
Senator Wagner.
Thank you, Mr. President. I think this is a prudent amendment, and it allows our FFL dealers to have a better outcome, not the best outcome, but a better outcome, and I think that's what we all want. The underlying bill essentially forces them into a distressed sale, and when you are forced into a distressed sale, you take pennies on the dollar for your equipment. People will know that they have no choice but to sell outside of the state and to take whatever price is offered. So rather than have a substandard outcome, I think we should go for the best outcome. And I would also add to the idea, Senator Wilson, Senator McCune made the point that it's really a whole class of firearms and accoutrements. Not only is it a large number, it's the most popular selling items. And in my town, we have gone from 3 FFL dealerships down to a single dealership, and I would add minority-owned shop. I want to see Key's shop in Cedar Woolley have a better outcome, and I think this amendment will help that happen.
If there are no further remarks, the question before the Senate is adoption of amendment number 0448. As many are in favor, will signify by saying aye. Opposed, no. Noes appear to have it. The noes have it. The amendment is not adopted. Further amendments, amendment number 0447. The Secretary will read.
On page 13, line 34,
Last
after
line.
section, assault weapon previously purchased for law enforcement purposes.
Senator Wilson Linda.
Thank you, Mr. President. I move amendment number 0047 to be adopted.
Close. Senator Wilson moves adoption of amendment number 0447. Remarks, Senator Wilson.
Thank you, Mr. President. So this is similar to one that we heard just a couple of minutes ago. I had a constituent contact me who was a law enforcement officer in Las Vegas and retired there in 2004. But he told me that there were many people, many law enforcement officers that had the ability to purchase their personal firearm and train with it and use it during as a law enforcement officer. And he said that Colt Manufacturing actually has a model that's specifically made for law enforcement officers. So he personally purchased one of those, and his concern was He retired in 2004 in Las Vegas and then moved to Washington. So he said, I wouldn't be able to bring that with me now, but I did bring them. He did bring them with him when he moved. And so he said, with the police that we have now, and if we're trying to encourage more police officers coming from outside of the state to hire them inside, and they've been had a firearm like this for a long time, and that's the one they're using. They're very comfortable with it. They know the firearm. It makes a lot of sense to allow them to bring it into the state when they come to retire here. So I would encourage a yes vote. Thank you.
Further remarks, Senator Dingra.
Thank you, Mr. President. Unfortunately, rising for a no vote on this amendment, as was stated just recently, we have the pleasure of doing this debate again because of an amendment that we had taken on the Senate floor that's similar to the one that Senator Wilson is suggesting. But unfortunately, that is out of the scope and title of the bill. And so I think there are some good ideas on this amendment, along with another one that I think we'll be talking about shortly. But I think those are great ideas for a bill next session. And I think there are some members that may be interested in working with other members on getting something together for next session. But for now, I'm going to ask for a no vote.
There are no, Senator Wagner.
Well, thank you, Mr. President. Rising in support of the amendment, another body felt that it was out of scope. That's not what our body decided. And I want to remind this body that we are not a subordinate branch. We're an equal branch on status with every other section of our state government. So I don't think that we should be considering the merits of the bill within this body based on a ruling made outside of this body. And that ruling was made, or rather our decision to accept the aforementioned amendment was made right here with all the brilliant attorneys present. They would have caught it if it was out of scope by our rules, and we need to assert our equality. Thank you, Mr. President.
There are no further remarks. The question before the Senate is adoption of amendment number 0447. As many are in favor will signify by saying aye. Opposed, no. No. The noes appear to have it. The noes have it. The amendment is not adopted. Further amendments, amendment number 0450, the Secretary will read.
On page 13, line 34, after section
Last
strike
line.
4, returning to Washington State as their home of record.
Senator Wagner.
Mr. President, I move amendment 0450 be adopted.
Senator Wagner moves adoption of amendment number 0450. Remarks, Senator Wagner.
Thank you, Mr. President. This amendment would allow the importation of a assault weapon by military retirees returning to Washington as their home of record. So everybody in the military has a stated home of record. And in my career, it was always Washington State. You go abroad, but you always belong to Washington. I think it is only fair that we allow people who have served in the military to bring back their legally acquired property. And there are probably hundreds of people who were in my shoes. It's long behind me now, but people just like me who had their firearms with them and now will not be able to bring them back to their home of record. So I think we should show our military personnel that we support them, that we understand the sacrifices they made and the special lifestyle that they lead, and approve this amendment.
Further remarks, Senator Dingra.
Thank you, Mr. President. Rising in opposition to this amendment, I would say I am practical, if nothing else. And while I'm enjoying this debate for the second time, I would prefer not to have this debate for a third time. So I'm going to ask for a no vote.
Further remarks, Senator Patton.
Thank you very much, Mr. President. I would just point out that this amendment is before us. There's no challenge. And while all 49 of us may have opinions on what is in scope and object. With no challenge, there's no ability, Mr. President, for you to make the ruling. And your ruling, frankly, is the only one that counts, not what the rest of us think. So this is before us, and we should vote on it on the merits of the amendment, whether or not we want to give some respect here and accord to our military retirees that are returning to their state of record, the evergreen state. So I'd urge a yes vote on the amendment.
There are no further remarks. The question for the Senate is the motion to adopt amendment number 0450. As many are in favor, will signify by saying aye. Opposed, no. Noes appear to have it. The noes have it. The amendment is not adopted. Further amendments, amendment number 0452, the Secretary will read.
On page 13, line 34, after
Last
section strike,
line,
to Washington State.
Senator Wagner.
Mr. President, I move adoption of Amendment 0452.
Senator Wagner moves adoption of amendment number 0452. Remarks, Senator Wagner.
Thank you, Mr. President. Well, last week, I thought we did good work in this body by approving an amendment that is similar but not the same to this amendment, that shows we understand that military life is different and requires sacrifice, and also requires people to do things they may not want to do, such as move to Washington State. This would allow active duty military personnel to bring their legally acquired firearms to Washington State. I would reiterate that we are not a subordinate body. The idea that we don't want to do a tug of war with another body, I think, is not a great argument, in as much as we are correct, and they are not. I would also reiterate that military personnel have no choice whether they're coming to Washington State or not. They have no choice. That's why they're called orders. And to turn our backs on them and say, you're going to have to dispose of your property, you can't bring it with you, I think is a slap in the face to the sacrifice, and it doesn't respect the difference in their lifestyle and what they do for the country. And the way things are now, we may soon be relying on them. Even foreign governments, when I was serving, I was stationed overseas for 13 years. Even foreign governments allowed us to bring our firearms under the Status of Forces Agreement because they understood that we had a different lifestyle. If we can't give our military folks the same kind treatment that a foreign government gave me, I think we're doing them a great disservice. But I think we're going to do the right thing here today with this amendment. And I think everybody would like an opportunity to show that they support our military men and women. So I would demand a roll call vote and ask for your support of this amendment.
Senator Wagner demands a roll call. Do 1/6 of the members join in this demand? The demand is sustained. Further remarks? Senator Dingra.
Thank you, Mr. President. I want to make sure this body is absolutely very, very clear that everyone supports our military personnel. We thank them for their service, their sacrifice, not just them, but their entire family and what they have to go through. We also have to be realistic about the bill, the title, the scope that's before us. There's a lot of merit to what Senator Wagner has said about this, and I think this would be a really great bill that many on my side of the chamber would love to work on with Senator Wagner. And I think we can have a good policy that pertains to the men and women in the armed forces and their access and use to assault weapons. That, however, is a bill for next session. And I'll just end by saying, there is absolutely no doubt that everyone in this chamber supports the brave men and women who serve our country and do us proud.
Further remarks? Senator Short.
Thank you, Mr. President, rising in support of the gentleman's amendment. And I appreciate the comments the gentlelady made. But the reality of this bill is there's an emergency clause, which if the governor signs into law will take effect immediately. So we have military men and women in active duty service that will be impacted by this law. Quite frankly, we can amend titles and we could add this language and we could do them a service, the same service that they are providing to us every day and their families. And they are going to be caught in the middle of this, unfortunately. And I am grateful that the support is there, but let's do the support right now today. Vote yes.
Further remarks, Senator Wagner.
Oh, thank you, Mr. President. Again, I would say the scope of this amendment has not been challenged in this body. And I think Senator Padden's comments are right. On that point, it's your opinion that would matter, but it hasn't been called into question in this body. Also, I would say platitudes are lovely. Let's show people we mean it by helping them out. This is going to put a lot of people in a jam. And we have the ability to prevent that right now by amending this bill, accepting this amendment. And I do hope that we will all vote for it. Thank you, Mr. President.
There are no further remarks. The question before the Senate is adoption of amendment number 0452. The previous demand for roll call was sustained. The secretary will call the roll.
Billy. Minky. Braun. Cleveland. Conway. Dingra. Dozier. Fortunato. Frame. Gildon. Asagawa. Hawkins. Holy. Hunt. Kaufman. Kaiser. King. Cooterer. Leas. Lovelet. Lubbock. McEwen Drew. McEwen Jim. Mullet. Mazzal. Wynn. Nobles. Padden. Peterson. Randall. Rivers. Robinson. Rolfus. Saldana. Solomon. Chesler. Shoemake. Short. Stanford. Torres. Trudeau. Valdez. Van de Weg. Wagner. Warnick. Wellman. Wilson Claire. Wilson Jeff.
Aye. Aye.
Wilson Linda.
Senator Wilson Claire. Senator Trudeau. Senator Trudeau votes no.
Mr. President, there are 24 aye, 25 nay.
Having failed to receive a majority vote, amendment number 0452 does not pass. Further amendments? Amendment number 0453, the secretary will read.
On page 13, line 34, after
Last
section strike,
line.
for a loan is not a purchase or sale prohibited under this act.
Senator Fortunato.
Thank you, Mr. President. I move amendment 0453.
Senator Fortunato moves adoption of amendment number 0453. Remarks? Senator Fortunato.
Thank you, Mr. President. We're going to try this again. And when we brought this bill up before, I ran a similar amendment. And the purpose of that amendment was to clarify plainly in law so that somebody didn't have to go to a lawyer and have somebody interpret it. After I ran that amendment, Mr. President, we were told on the floor that a person that brings a firearm into a pawn shop and that pawn shop loans against that firearm, that is not a sale, it is not a transaction that is subject under this particular bill. Since then, I have asked the Attorney General to give me a ruling on that, both formal and informal, and I have yet to receive that. I'm hoping that this particular amendment will simply clarify this is not a sale, it is a loan against a firearm, and that transfer back to that person is exempt under this particular bill. It is important that a normal person should be able to read a law and see, oh, I see that that's exempt. Without this amendment, who is going to interpret the law? Who is going to figure out whether that transaction is a purchase or a loan, transfer, et cetera? So this is a clarifying amendment, pretty simple. Urge your support. Thank you.
Further remarks, Senator Dingra.
Thank you, Mr. President. Rising in opposition to this amendment, and the good senator from the 31st District is right. We did have this colloquy and this discussion the last time we talked about this bill, and that time as well, I had said that there was an email sent from the Attorney General's office to the Washington State Pawn Brokers Association clarifying very clearly that when you use the weapon as collateral, that is not a sale. And so under this bill, this does not prohibit transfers for the purposes of collateral. You can do that, you can get it back. So this amendment is not needed. This provision has been clarified multiple times. Thank you.
There are no further remarks. The question before the Senate is the motion to adopt Amendment 0453. As many are in favor, will signify by saying aye. Opposed, no. The noes appear to have it. The noes have it. The amendment is not adopted. Further amendments, amendment number 0449, the Secretary will read.
On page 15, beginning on line 5, strike
Last
all
line.
section. People.
Senator Patton.
Thank you, Mr. President. Move that Amendment 0449 be adopted.
Senator Patton moves adoption of amendment number 0449. Remarks, Senator Patton.
Thank you, Mr. President. As has been commented on the floor here, this bill has had an interesting journey, and we certainly spent a lot of time in the Senate Law and Justice Committee. All 11 members of us had input on this. A number of amendments were offered, and unfortunately, very few were adopted. There was one by the good gentleman from the 43rd District. But let's just say it was a very spirited debate. Then we had that debate here on the floor. And then because of the ruling in the other body, we get to have another debate. But what this amendment does is I think through this debate, folks are being educated. They're certainly seeing that all the gun control laws that we've had in this state haven't done very much to reduce crime with firearms. And maybe if we took a different approach, that would be better. I'm sure folks on the other side have a different opinion. But what this amendment would do would give both sides an opportunity to debate this by having a referendum clause instead of the emergency clause. And as you well know, Mr. President, without this amendment, all we have left is the emergency clause. And I'm not sure if there's an emergency. I think the Attorney General has been calling for this a piece of legislation as long as he's been in office. So, I mean, a lot of time has gone by, and I'm not sure there's an emergency. But regardless, if the bill was adopted without this amendment, the emergency clause stays in. That denies the citizens of our state, the 7 million plus citizens, the opportunity to debate on this. And not only do we have a crime spree going on in the state, and we have huge vacancy rates in downtown office buildings in Seattle, Tacoma, and Spokane, but we also are dealing with folks, especially females, that are purchasing more firearms. So firearm sales have gone up. The percentage of citizens that own firearms has gone up. And even, I dare say, the folks that maybe don't own firearms see the need and see why an individual would want to protect themselves, especially females that may need a firearm as an equalizer with all the crime that we have going on. So this is an opportunity to support we the people, to support the efforts of the people to vote on this and make a decision if they want this bill as a whole, which we have debated. Let's give that same right to our citizens, to the constituents we represent, approximately 158,000, maybe to 160,000 citizens, each of us. Let's give them the same right that we have exercised here on the floor of the Senate. Thank you, Mr. President. Oh, I demand a roll call vote.
Do 1/6 of the members join in the demand for a roll call? The demand is sustained. Further remarks? Senator Dingra.
Thank you, Mr. President. Standing in opposition to this amendment. Mr. President, when we had the public hearing in the Law and Justice Committee, I had a member of the press come up to me afterwards and ask me whether I had been strategic in scheduling the hearing that week. And what he meant was that there had been a mass shooting earlier that week. And my response to him was, it didn't matter which week I scheduled the hearing, because unfortunately in our country, there would have been a mass shooting that week. And here we are today again, where I can say within a week, there has been a mass shooting. I don't know how we declare an emergency, but the number of mass shootings in this country should abhor each and every one of us. Everyone should be working hard to make sure we don't allow this to happen over and over and over and over and over again. The rest of the world has figured it out. We just haven't here in the United States of America. And that's what this bill is about. It's not about crime in general or violence in general. This is about sensible gun violence policy. And Washingtonians over and over again have overwhelmingly supported sensible gun violence policy. And this is why we need to vote no on this amendment. Thank you.
Further remarks? Senator Fortunato.
Thank you, Mr. President. I agree with Senator Dingra's statements. It's happening over and over and over again. But it's not happening by law-abiding citizens. These crimes are being done by people, in some cases mentally unbalanced, planned, etc. And yet, our solution to that is not to perhaps protect our children in school by having an armed response. Do I like having armed people in our schools? No. Do I like having our children be able to be subject to a mass shooter coming in and indiscriminately shooting children before somebody calls 911? No, I want our children protected. I don't want our children protected by the time we seize everybody's 30 million AR-style rifles with 79 million magazines.
Senator Fortunato.
Senator
Fortunato, the President reminds you that the question before the Senate is Senator Padden's amendment to add a referendum clause. Please proceed.
Thank you for that kind reminder, Mr. President. This amendment will allow the citizens of this state to determine whether they want this bill or not. Once they find out all the intricacies and how this applies and how this will disarm them, I believe that they will be anxious to sign a referendum. And this emergency clause prohibits that. So this is a very important amendment because we believe that all the power is inherent in the people, Mr. President. Urge your support. Thank you.
Further remarks, Senator McCune.
Thank you, Mr. President. Well, this is an important amendment. It's kind of an amendment that I ran last time, and I stand in support of this amendment. Having a referendum in the state of Washington is very hard already. I mean, you get in and you got to gather signatures, and it's really tough to accomplish that anyways. But the people in Washington State love to have the chance to do it. I don't know if they're going to file a lawsuit when the bill's signed, or they like to run a referendum. I have no clue what they're going to do. But the people's right to run a referendum is very important to the people of the state of Washington, and taking away that right is not right. And some of the previous speakers got off course. There's no doubt about it, and I might do that a little bit myself, because the problem really here in the state of Washington is mental health, and all across the U.S. It's not the legal gun owner. It's mental health, and we're not dealing with mental health. I think in 2006, 2008, when we had a downturn, we let mental health people out of institutions, and they become homeless all over the state. We weakened the drug laws, and we got homeless people all over the state. But anyways, that debate was going on here, and you questioned one person, but you didn't question another. You should have, but you didn't. But the right to referendum is important to all citizens in the state of Washington, whether they want to run it or not. I think it's important to them. And I think we need to pass this amendment. It's a very important amendment to honor the referendum in the state of Washington. Thank you.
If there are no further remarks, the question before the Senate is adoption of amendment number 0449. The previous demand for a roll call was sustained. The secretary will call the roll.
Billig. Binky. Braun. Cleveland. Conway. Dingra. Dozier. Fortunato. Frame. Gildon. Hasagawa. Hawkins. Holy. Hunt. Kaufman. Kaiser. King. King. Cooter. Leas. Lovelet. Lovick. McEwen Drew. McEwen Jim. Mullet. Mazzal. Wynn. Nobles. Padden. Peterson. Randall. Rivers. Robinson. Rolfus. Saldana. Solomon. Schessler. Shoemake. Short. Stanford. Torres. Trudeau. Valdez. Vandeweghe. Wagoner. Warnick. Wellman. Wilson Claire. Wilson Jeff.
Aye.
Wilson Linda.
Senator King, how do you vote? Senator King votes aye. Senator Nguyen? Senator Nguyen votes no.
Mr. President, there are 21 aye, 28 nay.
Having failed to receive a majority, Amendment 0449 is not adopted. Question before the Senate is adoption of the striking amendment number 0445. Remarks, Senator Peterson.
Thank you very much, Mr. President. The striking amendment makes two changes to the underlying bill. The first is to adjust the definition of import to make it clear that those who legally possess assault weapons and take them out of state, for example, on a hunting trip, may legally bring them back into the state without being considered to have imported the weapons. That's consistent with the treatment that we have in the statute for high-capacity magazines in the bill that we passed last year. The second change is the floor amendment by the gentlelady from the 26th district that will allow small businesses to sell their inventory out of state, a change which is consistent with the title and the scope over in the other chamber, and I think will improve the bill as well. I urge your support of the striking amendment. Thank you.
Further remarks? Senator Patton?
Thank you, Mr. President. Urging a no vote. I think really all you have to do is look at the intent section. We didn't have any amendments on that this time, but we talked about it before. But they talk about, Mr. President, hyper masculine, trying to market these things to troubled young men. That simply doesn't exist. It's a falsehood, and it's in the intent section along with a lot of other stuff that is, I would say, hyper on the other side of the issue. So that alone ought to be a concern. But there are serious, very serious legal issues. As we've discussed before, we are waiting a ruling on the Miller v. Bonta case out of the Southern District of California. Judge Benitez is expected to issue a ruling very shortly. And the governor of California has indicated that he believes Governor Benitez will rule their bill, their so-called assault weapons ban bill, unconstitutional. And that bill is extremely similar, including the listing of the different types of firearms to our bill. So, and of course, that is based on the Bruin decision by the Supreme Court, which indicated that the standard now is to look what the historical record was at the time our nation was founded back in 1791 era. So, and in addition, we have the case out in New Jersey where the federal district court judge told the legislature in New Jersey they shouldn't have enacted the bill. And I think we're about in the same state as New Jersey. And I do think there will be lawsuits filed right after the governor probably signs this, should he sign it. So there's serious legal things, and that, of course, is going to be a cost to the taxpayer of this state when those legal fees probably will be ordered for the state to pay when the case is ruled unconstitutional. There's a lot of other concerns in this. I'm sure other members on our side will point out this, but I would again urge a no vote on this new revised version of 1240. Thank you.
If there are no further remarks, the question before Senator Gildon.
Thank you, Mr. President. So I'm going to kind of limit my remarks. I'm not going to speak so much about the constitutional issue or the legal battle or any of that, because the courts are going to do what the courts are going to do, and I think most people's minds are made up on that issue. But anyone who's known me for any amount of time knows that I always try to look at the root causes of the issue. What is the root cause of the problem that we're trying to fix? And that's something that I picked up, a long time ago after reading Dr. Stephen Covey's book, The 7 Habits of Highly Effective People, which I'm sure you're very familiar with. But habit number 5 of that book says, you must diagnose before you prescribe. And with that in mind, I'd just like to share a little bit about why I'm not going to be supporting this bill today. And it's largely based on my own experience. So, as you know, I've spent 23 years in the military. I've spent about 5 years overseas deployed to combat zones. During all of that time, Mr. President, living on small base camps with people from different armies all across the world, different cultures, different religions, different languages, everyone was carrying actual military-grade assault weapons 24 hours a day, 7 days a week. And in all that time living overseas, I never once experienced violence on those base camps. There was never any gunfights. There was never even any fistfights that I experienced. And I have to sit back and ask myself, why is that the case? Why was there no violence on those base camps despite people being heavily armed and quite honestly, living in very stressful environment where they could have been attacked at any particular time? So why was there no violence? And I think it boils down to me, to the fact that it boils down to mental health and a value that we place on human life. Because we knew that we were in such a highly stressful environment, we paid particular attention to the mental health of our brothers and sisters in arms. If we saw someone who was having a rough time, we tried to come to their aid and give them the assistance that they needed as quickly and as best as we possibly could. And then we also placed a high value on the lives of those around us because we needed each other and we all knew that. So as I back down this and I'm considering this particular bill, I have to ask myself, are guns the root cause of the problem, or is there possibly a larger societal problem that we should be considering and we should be spending all of this legislative effort on? And we are making progress in this area of mental health for our society. That's going to take some time, I acknowledge that. But for me, Mr. President, I do not have confidence in the diagnosis of this problem, and therefore I cannot endorse the prescription as asked for in this bill. Thank you.
If there are no further remarks, the question before the Senate is the motion to adopt striking amendment number 0445. As many are in favor, will signify by saying aye. Opposed, no. No. The noes appear to have it. Division's been called for. All those in favor, please stand and remain standing until your vote is counted. The ayes have it. The striking amendment is adopted. Senator Peterson.
Thank you very much, Mr. President. I move that the rules be suspended, that Substitute House Bill 1240, as amended by the Senate, be advanced to third reading, the second reading considered the third, and the bill be placed on final passage.
Senator Peterson moves that the rules be suspended. Substitute House Bill 1240, as amended by the Senate, be advanced to third reading, second reading considered the third, and the bill be placed on final passage. Hearing no objection, so ordered. Substitute House Bill 1240, as amended by the Senate, on third reading and final passage. Remarks? Senator Cooter.
Thank you, Mr. President. You know, the last time this bill was in the chamber, you spoke very poignantly, I think, about how emotional this issue is. In fact, I have a pit in my stomach just thinking about it, thinking about the fact that since we passed this bill off the Senate floor 10 days ago, there have been 20 more mass shootings. America has a gun violence problem, Mr. President. We have a gun violence epidemic, and we're willing to talk about everything else but the one constant in all of it, and that's the gun. And that's what this bill does, is it focuses on a certain kind of gun, an assault weapon. May I read, as long as Senator Patton brought up the intent section, may I read a few sentences from it, Mr. President?
Please proceed.
Thank you. The legislature finds and declares that gun violence is a threat to the public health and safety of Washingtonians. Assault weapons are civilian versions of weapons created for the military and are designed to kill humans quickly and efficiently. For this reason, the legislature finds that assault weapons are like M16 rifles and thus are weapons most useful in military service. Assault weapons have been used in the deadliest mass shootings in the last decade. An assailant with an assault weapon can hurt and kill twice the number of people than an assailant with a handgun or non-assault rifle. And this is because the additional features of an assault weapon are not merely cosmetic. Rather, those are features that allow shooters to fire large numbers of rounds quickly. And Mr. President, there are families all across the United States and including here in Washington that know that feeling. They know how quickly their loved one was gunned down and their loved one's never coming back again. That's what we're here to talk about today, Mr. President. Enough is enough. We have to talk about the assault weapon. We have to talk about its role in our culture, and we have to talk about its role in the number of deaths that we see in Washington state. May I read just a couple statistics specific to Washington, Mr. President?
Please proceed.
Every year, 810 Washingtonians are killed by guns. That's a rate of 10.5 per 100,000 persons. Someone is killed by a gun every 12 hours in Washington state. Gun violence is the leading cause of death for children and teens. Gun violence costs Washington state an average of $5.3 billion every year. More people are killed by guns than they are in car accidents, Mr. President. I don't know how many more statistics we need to have. I don't know how many more families need to suffer needlessly. How many more little students aren't going to come home from school? And how many more are going to go to school feeling scared to death whether they're going to come home? It's time that we act like the responsible adults that the young people are demanding we act like. They will hold us accountable. They will rightfully hold us accountable for our actions today and going forward on this issue, because it is one of the preeminent issues of our time. And as Senator Dingra so correctly pointed out, other countries have figured this out, Mr. President. We can too, but we have to be willing to put people before profit and people before guns. Please vote yes on this bill.
Further remarks? Senator Fortunato.
Thank you, Mr. President. Most mass shootings were done with pistols, not a AR-style rifle. I just want to point out that the term assault weapon is a totally made-up term by the anti-gunners to instill fear. We are told that they are M16-like, but they're not M16s. The only difference is cosmetic. It is cosmetic. It's not the same thing. You are not allowed, since 1935, I think it's Miller versus US, about automatic weapons, Mr. President. But we are actually not the only ones debating this. I had an inquiry while we're debating this on the floor, and I'm wondering if Senator Dingra, I've asked her if she would yield to a question on what happens with a traveler going through SeaTac with a AR-style firearm, maybe on his way to Alaska or on his way on a hunting trip somewhere else. And in New Jersey, Mr. President, a person was arrested because his flight was delayed. He had to pick up his luggage, which included a firearm. And he was arrested because he violated New Jersey's law at the time. So what would happen, we've all experienced, we're going through SeaTac Airport or we're going somewhere, canceled flights delayed, et cetera. I know if I had a firearm, I would want to make sure that that firearm was protected. I don't want it laying around in SeaTac Airport somewhere. If a traveler was able to pick up that firearm, or if it simply passed through SeaTac, not in the traveler's possession, would that be an exempt situation since it's not transferred? He doesn't have it in his possession. It's going through the baggage claim. And then What would happen if his flight was canceled and he had to pick up that firearm? Would he be in violation of the import on this particular bill? So that's a question I would like to ask, and hopefully I could get an answer. Thank you, Mr. President. Yield to a question.
Senator Dingra, do you yield?
Sure, Mr. President. As I told Senator Fortunato, normally you're not allowed to carry a weapon as a carry-on. It's in checked baggage. And so I think it really depends on what the circumstances are, and if there's a flight delay, it's very hard to say. And as an attorney, I'll say it depends. But normally you're not carrying an assault weapon as carry-on.
Further remarks, Senator Wagner.
Thank you, Mr. President. Obviously, rising in opposition to the bill. I will say that there's only one thing I agree with in the intent section. That's the very first sentence. And the rest of it, I think, is somebody's fantasy. But the fact that I probably have as much experience as anybody in this room with military weapons, with M16s, with AR-15s, knowing more about it is not convincing anybody. I understand that. So I'm just going to say this. It's going to pass, I'm sure. I'm sure it will be signed by the governor. It's not going to make a difference. It's not going to change anything. And we took away our opportunity to at least study that out in the future and see if it had an effect. I hope that we undo that somewhere else. So it's going to be struck down. It's not going to change anything. I'll be voting no.
Further remarks, Senator McEwen.
Thank you, Mr. President. Tough issue for sure. Every one of us on here agrees that there is a problem in this country, without question. And we can debate, is this bill going to change it or not? And I know we're not going to change each other's minds on the floor here today. And there's something inherently wrong in our culture today that has led to a lot of this. And I would just challenge all of us to look deep at that issue. I grew up in a small town in the upper Midwest before the Navy plucked me out of there and brought me here. And at the time, when you could, it was not uncommon to pull up in the parking lot and there's guns in the back of people's pickup trucks in their windows, and it was a common sight. It was a hunting community. And today, if that happened, it's a totally different scenario. Things have changed. I recognize that, but also recognize that I think we try too hard sometimes to seek out a solution that ends up being heavy-handed and harms the very people that are following the law. And I think that's the point we're trying to make here today. And I look at one of the other statistics in this state. Last year, roughly 2,500 people died from drug overdoses. Let's address that issue with as much aggression as we are addressing this. And I mean that in a sincere way, I don't mean that maybe the way that came off there, but let's look at everything that is causing our cultural decay. Let's go after the mental health issues in this state. And somebody that has evil in their heart is an intent on inflicting that, we're not going to be able to stop them. No amount of legislation on this floor is going to change that. But we've got to stop minimizing the actions of people that do wrong. And let's look at everything. It's time that we have responsibility and return to a culture of personal responsibility. And again, we're not going to change that here today either. I rise in opposition to the bill in defense of those that exercise their rights responsibly and legally. And I also recognize the emotion, though, of what we face today. And I just offer up that there's other solutions that we must look at. Let's not kid ourselves that this is going to suddenly change it, because people intent on doing harm are going to do it regardless of what laws we pass. I ask for your no vote, and with all due respect, let's lock arms and address the real issues that are in our culture today and get those taken care of. Thank you, Mr. President.
Further remarks, Senator Trudeau.
Thank you, Mr. President. I had mentioned before in our previous debate that I'd been working on this policy for some time, actually working closely with someone who did serve in the military, did 2 tours overseas, and was very familiar with many of the issues that we've been discussing here on this floor. But I come from this, Mr. President, today and in this session as a mom and as a member of a community that has been disproportionately impacted by gun violence. And I'll tell you, Mr. President, that my community expects me to vote for this bill. My children expect me to vote for this bill. And frankly, youth across this entire country expect us to vote for this bill. They have spoken, they have taken to the streets, Mr. President, and they are begging us to do exactly what we are doing here today. You know, Mr. President, we do know the data, and you know, we can talk about legal firearms owners, and I have respect for the Second Amendment as much as the next person. We know that there are no absolute rights, Mr. President, that are guaranteed for us, that we must balance our rights as citizens that operate here in this country with the balance and the safety and needs of everybody else that we interact with and are in community with, Mr. President. But I would point out that the vast majority of mass shooters actually acquired their firearms legally. In fact, many of them were not even tracked as having mental health until after the fact, Mr. President. And we can talk about having a broken mental health system. You know, I advocate vigorously for investments in mental health. I advocate vigorously for investments in housing. I advocate vigorously for investments in behavioral health, Mr. President, because I do believe that we need to have solutions that address the systemic issues that we have in our culture. That's absolutely true. But what we have in our society, Mr. President, that is unique is that we have a combination of these issues and, frankly, easy access to firearms and a distorted gun culture, Mr. President. That is what causes us to be unique from other countries that are similarly situated, who also have mental health issues and substance abuse issues and violence issues. Mr. President, we are not unique in that sense, but there is something that makes us unique, and that is that access to firearms and a distorted gun culture. So, you know, I think we forget sometimes when we center ourselves and the good behavior that we exemplify, that we are legislating for those that don't exemplify that same behavior, Mr. President. And there are often people that we forget. And I want to bring up one person that is incredibly special to me, Mr. President, and that's my brother Naeem. And my brother Naeem experienced a lockdown because there was a call that there was going to be a mass shooter in his school. And there was a lockdown at Stadium High School. And he had to be picked up from school, Mr. President. He wouldn't speak. He wouldn't eat unless it was underneath his covers for almost 3 days. And that's because, Mr. President, my brother has cognitive and physical disabilities that limit the way that he interacts with issues that we may all be able to assess carefully and thoughtfully. He gets overwhelmed, Mr. President. He doesn't know what to do when things are happening around him. And when that lockdown happened, he was scared, he was confused, and it has taken him up till now to even be able to start talking about that. But what scares me, Mr. President, is that when that shooter comes to his school, because it is a matter of when and not if. We've had more mass shootings in the last 10 days than there have been days. We have more mass shootings in a year than we've had days so far in this year. So when that happens, to know that my brother is going to be caught in that crossfire, Mr. President, because he's going to be confused and he's going to be scared and he's not going to know what to do and he won't be able to follow the directions even as they practice lockdown after lockdown, Mr. President. And so I take a vote today for him and for all of the other youth that are speaking, that are begging us to do something. Because while we have many issues that we need to tackle, and I look forward to tackling them with this body, I think we need to recognize that we're in a unique situation and that we must legislate for the problems that we have right now and for those that are bad actors, and commend those that act responsibly, but act for those who don't. And that's why I'm going to be voting yes, Mr. President. Thank you.
Further remarks, Senator McCune, Jim.
Drop my paper. Thank you, Mr. President. Well, we like to call them, or certain people like to call them assault weapons. They're not assault weapons. They're only assault weapons when somebody takes a weapon and assaults somebody. It's pretty simple. We don't go to the store and say, look on the shelf, I want to buy an assault weapon today. We don't do that. We go to buy them for the use in sport or competition shooting, duck hunting, you name it. And I love beachcombing in Alaska where there's grizzly bears and I carry a shotgun. But a lot of Bayan citizens don't go out and commit mass shootings. They just don't. And this was what the Second Amendment was made for, law-abiding citizens. And like I stated before, we have a tremendous mental health problem in the state of Washington. I drive by it every day. I come down this highway here, this freeway, and I say, I should put up a welcome to Olympia sign up right where all those camps are, where all those drug camps are, and that garbage is lined up down the road. Welcome to Olympia. It's just a terrible thing. We have a mental health problem that's unbelievable, and we need to get on the work of dealing with mental health, Mr. President. And when all those gun statistics come out and you don't line them up right as they go down the list, 75% of those are suicides. It's pretty hard to stop a suicide and even tell if a person's suicidal. My neighbor last year shot herself and killed herself. And we knew she was lonely. She missed her husband that died a year ago. And we tried to invite her to a lot of stuff, and she didn't want to get out. And we knew her. The news was bad. All the news she watched was terrible. And we knew that, but we didn't know she was going to shoot herself with a .22 pistol her husband had. Whoever thought, we didn't know that. We went over next door, knocked on the door, and then opened. We opened the door, and there she was. But it was a sad situation. But 75% of those shootings a year are suicides. And they're very hard to stop as well. The enormous amount of mentally health people, and I don't have them as my district now that they redistrict Spanaway out of my district, but if you drive Spanaway, it's loaded with mental health people up and down. That place is a nightmare for Pierce County Sheriff's Department. It's just a nightmare. I'm told by people there, there's shootings going on every night. You hear gunfire. I love to bowl. I wanted to be a pro bowler, and I was at the bowling alley not long ago, and I just walked out with my bowling balls. I carry quite a few of them, and we heard bang, 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 and I thought, was that fireworks or was that shooting? Well, I learned the next time we came to the bowling alley, somebody up the street got shot. That's in Spanaway. I was at, and Spanaway is in lots of, it's just a mess. And it's mental health. Anybody that takes a gun, points it at somebody, and is going to tend to kill somebody has terrible mental health. They have no respect for life. So I like to see us deal on the mental health problem, which we haven't been dealing with at all. And then we have hundreds and sometimes 200 people shot by police officers fatally every year. And that's in the statistics too, of the number of people who are killed. And then we have domestic violence. And that was a terrible thing to happen in my district. The 2 police officers went into a domestic violence a few years ago. And he actually told the guy, go get his gear, and he was, come on out. But he went out and got his gear right. He got a gun and shot one of the officers dead. And that was a really sad situation. But domestic violence is a serious situation these days. We haven't really got a handle on that either. We've done some things here, but we really haven't got a handle on it. Then teen suicides run about 53% of those. And I don't know where the teen gets the gun, if there's a sloppy dad at home or mom that leaves the gun around. I have no clue. But that's another part of the statistics of the shootings that are going on in Washington State. And actually, to shoot yourself, you got to be pretty depressed. And what is the depression? Maybe they're coming from a broken home, the dad left the home, and there's a gun around. I don't know, but we need to deal with mental health. And mental health is the key to solving our problems. Not taking guns away from law-abiding citizens. In closing, I hope we can deal with mental health here in Olympia because it's serious. And welcome to Olympia sign right up here that I like to place shows that we have tremendous mental health. Thank you, Mr. President.
Further remarks, Senator Cleveland.
Thank you, Mr. President. We've heard on the floor today that gun violence is a public health crisis. And gun violence is preventable, Mr. President. Gun violence is not inevitable. But I want to offer a look through a bit of a different lens. A public health approach to preventing violence, Mr. President, recognizes that violence is contagious. It recognizes that we must interrupt the transmission of this contagious violence. And we do so with policies that data show really will lower the threat of that contagion, policies like the one before us today. So please support this bill, help to stop and prevent the cycle of violence. Thank you.
Further remarks, Senator Braun.
Thank you, Mr. President, and with any luck, hopefully closing debate. It's not a bill I've talked on either today or a week and a half ago when we first had it before us. And I want to start by just recognizing one of the comments made, as I recall, by our colleague from the 48th. She said, no doubt, and I agree with this, no doubt everyone on this floor comes to this debate with a sincere and genuine desire to protect our communities, to protect our families. I really believe that. And this is a difficult debate. And I want to also thank you, Mr. President, both today and in our previous debate for your steady hand. I very much appreciate that. And as you get to the policy, you know, I've been around firearms most of my life. I remember pretty distinctly, my father first introduced me to firearms when I was 9 years old. Mr. President, that's shockingly close to 50 years ago. Yeah, I've been involved in hunting and target practice and sport shooting. I have quite a bit of firearms training through the military. I'm very comfortable with firearms. I'd like to think I provided my children the same access, the same training, and they're pretty comfortable with firearms as well. I represent a very pro Second Amendment district. I believe that our state and our federal constitution protect our access to firearms. And that ultimately, you know, the courts will rule this bill to be unconstitutional. But let me tell you a couple things. December 6th, 2019, a gunman attacked at Naval Air Station, Pensacola, in the building that my son was attending as part of flight school. 3 service members were killed, including a young ensign that went to school at the Naval Academy with both my daughter and my son. Now, we were fortunate that day. My son happened to be stuck in traffic at the entry gate. 6 months later, May 21st, Naval Air Station, Corpus Christi. A gunman tried to enter the base. In that case, the guard, he was killed on entry by the guard. And thanks to the good training of his mother, our son texted us in both cases pretty promptly. He knew the right answer, and that was to let his parents know that he was safe. But I'll tell you, Mr. President, nothing focuses your attention like having a child in danger. Nothing. And it doesn't matter whether they're 3 or they're 23. I suspect 33 or 43. I haven't got there yet. So I'm very motivated to get after this issue. We have to find a way to stop these events, to at least slow these events. And I'm open to a whole range of solutions to get us there. This absolutely deserves to be our highest priority. I don't think there should be any question about that. But I don't think this bill gets us there, Mr. President. This is a very, very difficult problem. And I've thought a lot about it. And one of the pieces of advice I got from a colleague years and years ago is when you're faced with a difficult problem, it's relatively easy to fix things. It's very difficult to change people. This bill changes things. This makes legal access to these firearms illegal. Law-abiding folks will follow the law. They will not access the weapons. The lawless will not follow the law. Make them illegal, the lawless will buy them illegally, or they'll use a different weapon. We have a much more complex problem in front of us. To get after this problem, we have to change people. We have to change behavior. Many folks have talked about mental health. Certainly that's a part of it. Substance abuse, training, understanding of firearms, consequences for violent behavior. These are all part of it, Mr. President. Also part of it is building families, building communities, building a society that changes people's behavior, recognizing people that need help and helping them. No one problem is going to fix this, but I can tell you, I think with certainty, Mr. President, changing things won't get us there. You know, we commented earlier that the one constant is the firearm. I disagree with that, Mr. President. The one constant, the true constant in violence is people. That's what's always there, Mr. President. If we really want to solve this problem, we have to change people. And it will take all of us. So once again, I don't doubt that everyone here on this floor is sincere and genuine in their desire to protect our communities, to protect our families. But this bill falls short. Thank you, Mr. President.
There are no further remarks. The question before the Senate is final passage of substitute House Bill 1240 as amended by the Senate. The Secretary will call the roll.
Billig. Binky. Braun. Cleveland. Conway. Dingra. Dozier. Fortunato. Frame. Gildon. Hasagawa. Hawkins. Holy. Hunt. Kaufman. Kaiser. King. Cooter. Leas. Lovelet. Lovick. McEwen Drew. McEwen Jim. Mullet. Mazzal. Wynn. Nobles. Padden. Peterson. Randall. Rivers. Robinson. Rolfus. Saldana. Solomon. Schessler. Shoemake. Short. Stanford. Torres. Trudeau. Valdez. Vanderweg. Wagner. Warnick. Wellman. Wilson Clare. Wilson Jeff. No. Wilson Linda. Mr. President, there are 28 aye, 21 nay.
Having received a constitutional majority, substitute House Bill 1240 as amended by the Senate is declared passed. Title of the bill will be the title of the act. Senator Peterson.
Thank you very much, Mr. President. I move that substitute House Bill 1240 be immediately transmitted to the House.
Senator Peterson moves that substitute House Bill 1240 be immediately transmitted to the House. Hearing no objections, so ordered. Senator Peterson.
Thank you very much, Mr. President. I move that the Senate advance to the sixth order of business.
Senator Peterson moves that the Senate now advance to the sixth order of business. Hearing no objection, so ordered. Senate Bill 5333, the Secretary will read.
An act relating to creating the state sports special license plate, reenacting and amending RCW 46.
Last line.
New section, Section 5. This act takes effect October 1st, 2023.
Senator Levick.
Thank you, Mr. President. Mr. President, I move that the rules be suspended, that Senate Bill 5332 be advanced to third reading, the second reading considered the third, and the bill be placed on final passage.
Senator Levick moves that the rules be suspended. Senate Bill 5333 be advanced to third reading, second reading considered the third, and the bill be placed on final passage. Hearing no objection, so ordered. Senate Bill 5333 on third reading and final passage. Remarks, Senator Levick.
Thank you, Mr. President. Mr. President, I know it has been a long day and we have dealt with some tough issues. And I know we have a long day ahead of us. So I'm hoping, Mr. President, that I will be rewarded for being brief. There are currently 67 special design plates in Washington state. This bill will create a license plate to recognize the state sport, or the 68th license plate, the pickleball license plate. I would encourage a yes vote. Thank you, Mr. President.
There are no further remarks. The question before the Senate is final passage of Senate Bill 5333. The Secretary will call the roll.
Billig. Binky. Braun. Cleveland. Conway. Dingra. Dozier. Fortunato. Frame. Gildon. Hasagawa. Hawkins. Holy. Hunt. Kaufman. Kaiser. King. Cooterer. Leas. Lovelet. Lovick. McEwen Drew. McEwen Jim. Mullet. Mazal. Wynn. Nobles. Padden. Peterson. Randall. Rivers. Robinson. Rolfus. Saldana. Solomon. Chesler. Shoemake. Short. Stanford. Torres. Trudeau.